Answer, please. Everybody okay?
Yeah, we're fine. We were just having a chat.
What are your names?
I'm Rachel.
Rachel?
This is Valerie.
Valerie?
Mother.
Mother?
Mother.
Okay.
Yeah.
Okay. Do you want to step over here and talk with me?
Yeah.
My partner will come and talk with you for a second. It's Valerie in the car. Yep. What's going on?
We were just fighting.
Okay. We got a call that mom hit you.
I mean, she did, but she apologized for it.
Okay. That's what in the first time, right?
No, it's not.
Okay.
I didn't call Grandma.
I know Paul probably did.
Yeah. So
There's
we
nothing
got
going on. I mean, we're not pressing charges. That's my daughter.
right, and then that. So your mom.
It's her mother. I'm her grandmother.
Okay. So what happened today?
They just had a little confrontation in the bedroom. That's it.
Okay.
Nothing serious.
What
Nothing
happened
that we
with
need
the
to call the cops
confrontation?
for. I don't know why Paul had to call the cops.
So
He's
what
not
would
even
happen
me.
with the confrontation?
I mean,
She just wanted her keys back, and so they just went at each other for about a couple of minutes, and that was it. And then it was done, and then she got her keys, and that was it.
Okay. What was going on when I walked up in the car?
I was talking with my mom, trying to talk to her about what had happened. And my mom and my dad are going through a divorce. And earlier she was upset and she wanted me to pack all my dad's stuff and get it out.
Okay.
So that's what's in there. And I couldn't sit in the seat, so I sat. I know it's weird, but on her lap, so I could sit in the car and shut the door because it's cold outside.
Right.
She doesn't have coat on.
Okay.
But I couldn't get out of the car.
And I think of it as her husband is living with these people that supposedly they were neighbors. They had to move to a different city.
Mhm.
And apparently he's there. I don't understand why he thinks he can just, do whatever he wants to do and, take it in his own hands. I told him over the phone, it's none of his business.
Right.
Either him or his wife. I mean, yes, her husband is living with them, but still it's none of their business.
Definitely.
It's between the husband and my daughter.
Right. So it was just verbal.
Just verbal.
Just
that's all it
kind of
was.
yelling at each other, and then then she got her keys back.
Yeah, everybody
Or-
got their keys back. Yes, everybody
I got
has their
my keys back.
Okay.
I'm sorry they had to bother
No,
you for
it's
nothing,
okay.
which is ridiculous.
We're here to make sure that everybody's safe and everyone's
Everybody's
okay.
safe.
Are you safe and okay with what's going on today? Kind of looks like. Are you okay? Do you want to talk to me alone? You want to ask Grandma to go inside? You are 19, right?
She's
Yeah, I'm
19.
almost 20.
Okay. You mind just going inside and just her and I talking real quick? Thank you. What's your name?
Rachel.
Rachel. Okay. I understand that going through your parents' divorce and the two of them, fighting with each other. It's not something you want to see. I get that.
I understand why it's happening, which is yes, things are fine. My mom was real upset. She was throwing my dad's stuff. That's why I decided to pack it all up and take it. And she did take it.
This isn't your dad walking up, is it?
No, this is just right. Hello.
Just a neighbor.
This is just someone who walks.
So you were packing up dad's stuff?
Yeah, I was packing up my dad's stuff, and I was arguing with my mother, and at one point she did slap me because I said the wrong thing. I don't remember what I said, but I said the wrong thing.
Did you guys both get together?
But yeah.
Okay.
I still have a home for now.
Okay.
And
Let the record reflect I'm stopping at 5 minutes.
Your Honor, I'm going to object to the recording being stopped at that point, citing MRE 106. When a writing or recorded statement or parts thereof is introduced by a party, an adverse party may require the introduction at that time of any other part or any other writing or recorded statement, which ought in fairness be considered contemporaneously within. The statements immediately following this portion provide further context to the situation.
All right, so we can do this either way. Mr. Ring, we could have you play out until Mr. Moss is satisfied since the exhibit's been admitted. Or we can have Mr. Moss play a portion of his video during if he chooses to. Since it's admitted, it's anybody's exhibit at this point in time. Do you know how much more of the conversation would put this in context?
Not off the top of my head, Your Honor, I want to say not very long, a minute and a half, 2 minutes.
Couple minutes.
Yeah, that's okay. I can, I'll address it across.
All right. So with that understanding, the motion's withdrawn and so we'll stop at 5 minutes. And Mr. Ring, you may proceed.
Thank you, Your Honor. Officer McGregor, at any point, did you speak with any other party besides those two? At any point, did anybody mention to you that anything else had happened?
No.
When making this determination that an assault had occurred, did you make this determination by yourself?
No.
Did you make it with, or how did you make that determination?
I spoke to Officer Merlin, and we agreed with that in front of us
And Officer Merlick spoke with who?
with Valerie.
Thank you. No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. Good afternoon, Officer McGregor.
Good afternoon.
So you were not present when this situation occurred, correct?
Correct.
When you arrived, your body cam was on,
Yes.
and did you review your body cam footage in preparation of testifying today? Do you have any reason to doubt the accuracy of the body cam footage?
No.
If Valerie says that she acted in self-defense, you would not have any personal observations to refute that, correct?
I guess not.
Because you weren't there when it happened, right?
Correct.
Excuse me. One of the first things Rachel said was, she said, we were fighting. Isn't that right?
Yes.
And she was referring to her and Valerie.
Yes.
You never asked Rachel if she was the aggressor, did you?
Correct.
You never asked Rachel if she physically threatened Valerie.
Correct.
You never asked Rachel if she physically hurt Valerie.
Correct.
The statement, we were fighting, that implies a mutual struggle. Isn't that correct?
Correct.
Because a fight is an encounter between two, it's a violent struggle between two people. Would you agree with that definition?
Yes.
Is it possible that Rachel was the aggressor that day?
Yeah.
You were told that this fight or altercation was regarding some car keys, correct?
Yes.
And Rachel told you that the car belongs to Valerie, correct?
I don't recall.
Would you disagree with me if I told you that's what the body cam footage reveals?
Not true.
At some point, Rachel told you that Valerie went into her room with the car keys, correct?
Correct.
And then Rachel also told you that she got in Valerie's room and ended up getting her keys back. Isn't that correct?
Correct.
And hearing that, you didn't ask Rachel if she used force to gain entry into Valerie's room?
Correct.
You didn't ask her if she used force to get her keys back?
Correct.
You'd agree with me that those might have been some good follow-up questions to ask Rachel.
Yes.
You didn't look at the bedroom door, Valerie's bedroom door, to see if there were any damage to it. Isn't that correct?
Correct.
You didn't take any pictures of that bedroom door either.
Correct.
When you spoke with Officer Mulrick, who interviewed Valerie that day, He confirmed that there was a struggle over the car keys. Is that correct?
Yes.
Did you physically see Valerie and Rachel that day? You physically saw Valerie and Rachel that day, correct?
Correct.
Would you agree with me that of the two, Valerie appears to be the more frail individual?
Yes.
And you didn't observe any marks, any bruising on Rachel's face?
The where she said she was hit was a little more red than the other side of the face.
But you didn't initially identify where she was struck, correct? You had to ask her which side of the face she was struck on because you couldn't tell. But yet Valerie was arrested.
Correct.
Despite Rachel and Valerie both indicating to you and your partner that there was a mutual struggle over the car keys.
Yeah.
Isn't it true that Rachel asked you if she was going to be arrested that day?
Yes.
I want to play another snippet of your body cam. Fantastic.
So this was part of People's Proposed Exhibit 1.
Let the record reflect I'm resuming the body worn cam at 5 minutes.
Okay.
Okay, let the record reflect beginning play at 24 minutes and 39 seconds.
The record may so reflect.
Hey Rachel, could I speak with you real quick? What's your middle name?
Nicole. Am I gonna be arrested too?
What's your date of birth?
February 28, 2000.
Your Honor, I have no further questions for Officer McGregor.
Redirect.
Briefly, Your Honor, thank you. Officer McGregor, when you first asked Rachel, they said we were fighting. That's correct? But didn't you follow up on that, what that meant?
Yeah.
When you spoke with Rachel? And then she described to you what actually happened?
Yes.
Did anybody mention to you about a door?
No.
So you wouldn't have any reason to take any pictures of a door, would you?
Correct.
Unless somebody mentioned it?
Correct.
No further questions, Judge. Thank you.
May this witness be excused from the people?
Any questions from the jury? This witness may be excused.
All right, from the defense, any objection to this witness being excused?
No objection to this witness.
All right, this witness is excused. Thank you for your appearance today. It's 10-1, so it probably is a good time for a break before we get into another witness, I would think. And I have matters at 1 o'clock. So we will adjourn this case 23-00011 for lunch. And if you just keep in mind, you can't talk to anybody about the case, you can't, but you can go lunch. I would be back here about, what time? 2, I would say 2 o'clock. Be back here about 2 o'clock. I'll give you a full hour, and then we'll all convene with Nathaniel, and he'll put you back in the jury room, and then we'll bring you back, and we'll start listening to additional witness testimony. Okay. All right. So you're adjourned for lunch at this time. All right.
All rise for the jury.
You want to get that door?
Aaron, shut the door. Gotcha.
All right, so anything to come to the court's attention? I've got some sentencings at 1. We're gonna work till 2, and then that'll be about the time we get back on the record.
Not on behalf of.
Mr. Ring, anything else?
Not on behalf of people.
Mr.
Thank you,
Moss?
I'm not happy with the defense, Your Honor.
All right, we'll see everybody here at 2 o'clock, okay?
Is it okay to leave this cord out, Judge, or do you want me to try to tuck it back up?
I would be safe to tuck it, because we're gonna have some movement through it. And then
Yeah, I think that's what I was gonna do.
at least get it out of the way, because there will be some movement.
I'm just gonna drop it under your chair right there. That way nobody trips over it.
He was the no show.
I know I'd be the one that tripped over it.
Right. But he's also.
We're playing.
So I don't know if you wanna let him know he's trying to put it forward. And he was the no-show.
I think those are on the table. Just grabbing files.
Yeah. That's good. Huh?
Just gonna leave my water under the table,
Yeah.
just so you're aware that it's there.
Yeah.
And don't accidentally kick it.
Does
I'll
he
probably
have counsel? Because if his counsel's here, I don't want to talk to him without his counsel present.
Well, I just
Okay.
didn't know if you wanted to come yet.
Not my responsibility. I don't want to talk to him without his lawyer.
Okay.
I don't think so.
Did you guys receive the question? Okay.
If you get to the point where you're comfortable.
Mr. Alford,
I never got it. Felony either.
That's, I don't know.
Mr. Etheridge is a lawyer, I think.
I'm Mr. Alfred.
Let's do. I know.
Mr. Alford, that's you, right?
Yes,
All right. Why don't you stand by? We're waiting for your attorney to get here. You're supposed to be live in person, but you're by Zoom, so we'll just put this on the record, all right?
yes, sir.
Okay. Your case is set for 2 o'clock, but Mr. Etheridge's gonna be, my understanding, Mr. Etheridge might be here early, so we'll get you, just stand by, all right?
Yes, sir.
forward suggest concern in regard.
Testing, testing.
All right, Mr. Etheridge, you're here on Alfred.
Testing.
Mr. Etheridge?
Testing 1, 2, 3.
Can you hear me, Mr. Etheridge? Yeah, I don't hear him. He's back and come back. I hope. He was connected and everything, but I didn't hear him. Okay, waiting. Admit. Nope, no audio. Mr. Etheridge, give me a thumbs up if you can hear me. Yeah, he's not connected to audio. I'm gonna text him or...
I think it's working now.
All right, there you go, Mr. Etheridge. Can you hear me?
Yes, Your Honor. Sorry about that. Some technical.
No, just we've had quirks in the system all day long today. So let's go ahead and let's go on the record in. So this is on the record docket 2203552. People of the state of Michigan versus Larry Alford. Will the parties please introduce themselves for the record?
Jeff Braddock on behalf of the people, Your Honor.
Derek Etheridge, Office of Public Defender, on behalf of Mr. Alford. Your Honor, I'm appearing by Zoom from my office here at the Office of Public Defender. Mr. Alford is appearing by Zoom from his home in Georgia.
All right, you are Larry Alford?
Yes, sir.
All right, well, Mr. Alford, you're appearing by Zoom from Georgia, is that correct?
Correct.
All right, so Mr. Etheridge, I don't have a pre-sentence report on any type of sentencing on the 1-year misdemeanor because they haven't had any contact with Mr. Alford in order to set up in order to do a pre-sentence report. So I mean, I guess my natural inclination is to have Mr. Alford contact the probation department so we can set up some type of meeting so that we can have the sentencing. Any thoughts on that, Mr. Etheridge?
And I did talk to him about that. I got the email and forwarded it to him, and I thought that he advised me that there was never an appointment set up. He did come to Michigan at the time of the preliminary when he accepted the plea, and probation came in the courtroom and talked to the court about the ability to supervise him there in Georgia. But I guess I'll leave it up to the court's discretion whether or not a PSI is needed.
Well, I mean, he's because of his prior, he's not, I have limited opportunity. I guess I'd like to hear or see something from the probation, because if he's not put on probation, then he just gets a jail time, and I don't think that's, I don't want to do that unless there's unless I have a pre-sentence investigation and full report done. Mr. Out, so I guess my question is we really got to get him hooked up with probation so they can do a report for me, or else I'm stuck with no report for sentencing. And I guess that's my issue.
Well, Your Honor, I'm trying to remember. I know that he pled with 7411 if eligible, but I think his agreement also required that he would get no upfront jail. So I think he could still get probation if the court wanted to give him probation. I think if the court, I think if the
Go
court,
ahead.
I was just saying, I think if the court believes a pre-sentence investigation would help the court make a better decision, then I guess I'm all for that. I know he was concerned that he's not getting 7411 because he doesn't recall having a drug paraphernalia conviction on his record. And when I asked him,
I have a charge out of 2007, so he would not be eligible, which was part of the explanation, because I do not see it as a part of the, I don't have it on his record. So,
and Your Honor,
go ahead.
Your Honor, excuse me, Your Honor, I didn't mean to talk over you. I was gonna say, I checked this public iChat record, which is all I have access to, and it's not on there either. When we were working out this plea resolution, the prosecutor at the time didn't see anything on his record and believed he was eligible. So the other thing, Your Honor, I would bring up, and it's quite possible, the automatic expungement law goes into effect today that I don't know, maybe if it is even on there, which I don't believe it is, that it could possibly be expunged. And I don't know if that would help qualify him for 7411.
I don't, that's kind of what I want. The mention of that is my fear that, because I don't see it on his record, but I do indicate. So let's do this, I think your client has to get with probation so that they can interview him and so that they can talk and connect. It looks like I indicated that, Zoom reporting was all right through probation, but now it's just a matter of Mr. Alford getting with probation so they can prepare a pre-sentence report. So we have an understanding. So I guess my preference is to adjourn the sentencing, say at a 30-day time period, that the defendant needs to contact probation, explain to him all the indications, and also seek an explanation for the not eligible for 7411. Where does that possession of drug paraphernalia charge from 2007 come from? Because as you've indicated, and on mine, I don't see it on there. So, but I need to know why, I guess. I need to know where that comes from.
I would agree, Your Honor. I know Mr. Alford was anxious just to get sentenced. He was wanting to get it over with, and I told him I could challenge this because I don't see it on his record. And Mr.
Right.
Alford, I believe it's in your best interest with what the court's saying is just to agree to the adjournment so that we
I have
can.
no problem with that.
Okay, we would ask the court to do that then.
All right. So let's adjourn the sentencing. What Mr. Alford, what I really need for you to do is contact probation and get up with probation, answer their questions so that they can, and let's start by Zoom. Let's start by you contacting them by Zoom. Please don't do that. So let's start by calling them and setting up by Zoom so that we'll go from there. Okay. But but the key here is I can't sentence you. I don't think I'm qualified to sentence you without some type of report in this matter. Okay.
Yes, sir.
And so and there's a dispute right now as to a prior conviction on your record. And I think we got to work that out because it's kind of a big deal in your case right now. So
Yes,
let's
sir.
adjourn to resentence.
How do I get that information?
You don't get any information concerning the probation department from Mr. Etheridge, okay?
Yes, sir.
All right, and so we'll adjourn. I would set this as a priority. Contact probation as fast as you can, but we're gonna reset this for sentencing on
Okay.
about a month. I would say about a month. I'm gonna set it out a little ways to give you time for in order for this to work. All right. But if
Yes,
you
sir.
come back here and I don't have a pre-sentence report, we got a problem. All right. And I don't
Oh,
want to
yeah.
have a problem with this.
Oh, yes, sir.
So do you think 30 days would be sufficient, Mr. Etheridge?
I believe so, Your Honor. I did forward him the email that I received from the probation officer about not reaching out or contacting them for the PSI. So you just need to contact that probation officer based on that email, and I can forward you that email again if you
Well,
need it.
yeah, I called them yesterday and they said I never had an appointment. So it's a lack of communication somewhere. I called them, they said I never had an appointment.
You calling them yesterday is the day before the sentencing.
No, that's the
That's going to
first
be
I
a
heard of it.
problem.
That's the first I
Okay.
heard of it.
Your email response to me was that you called pretrial services and they said you didn't have an appointment. Make sure you call in probation and not pretrial services.
And Mr. Alfred, I told you on January 26th that
And I
you
went
had an
down-
April 11th at 2:00 sentencing.
I went down there the same day I left court. They gave me some papers to
Okay.
fill out. I filled out those papers.
We're doing this for you, Mr. Alfred. I mean,
Oh, I understand that. I
this
don't
is
have a
your
problem, sir.
sentencing, okay?
I don't have a problem. I'm just saying I reported today I left. The day I took the plea, I went straight there.
All right. Well,
Yeah, the court had him.
please
the court-
contact them. We'll resentence. We'll adjourn to resentence for contact with probation, since I don't have a pre-sentence and since we have a prior charge at issue. And for contact with probation, and we'll seek resentence at 3 to 4 weeks out.
Okay, I'll contact them today.
Yeah, Your Honor,
Ready for-
he is bringing up a valid point that whenever he came to Michigan for the preliminary, the court ordered him to see probation before he left by that following day, and he did do that. He's indicating and got the documentation and filled out and provided them.
All right. Well, whatever got done didn't get done with the way it was necessary. So, Mr. Alfred, call probation. Start with a phone call, and we'll go from there. Okay.
Yes, sir.
Because I need some kind of report, and something's not working here. But so
I'll get on it.
we'll set it for May 16th at 1:30. Explain to them you're living in Georgia. Explain to them all the processes, and then and explain to them. But you've got to reach out to them. You've got to contact them, because I need a report on that May 16th date. Okay.
Yes, sir.
And
All right.
when we get off the record, I'm gonna call you right when we get off the record, Mr. Alford, to talk to you briefly. Okay.
Okay.
All right.
All right. Thank you, Mr. Etheridge. Anything else on docket 22-03-552, Mr. Etheridge?
No, Your Honor. Thank you.
All right, Mr. Alford, prioritize this because we need to get that report done. Okay.
Yes, sir.
All right. We're all set on 22-03-552.
Thank you, Your Honor.
Thanks.
Thank you, Mr. Etheridge. Mr. Carter, you're here on Mr. Williams.
Yeah, but I'm early, I think.
Okay.
Your Honor, if we
could get Mr. Most out of here, I'm concerned about the heat in the courtroom.
Yes.
My computer
Yes.
just died, so I'm trying to get electricity.
We're trying to get as much as we can before 2:00 when the jury comes back.
Oh,
We got a jury out.
Okay.
Thank you, Your Honor.
Yep.
Commissioner for Mr. Most for your name, seated.
Absolutely.
Thank you.
You need to vote.
No, we're good. Yeah, we'll just-
All right, so we're on the record in docket 22-03297. That's people of the state of Michigan versus Gary Most. Will the parties please introduce themselves for the record?
Jeff Bredos on behalf of the people, Your Honor.
Good afternoon, Your Honor. Jacob Sarce, the fourth Assistant Public Defender here on behalf of Mr. Most. Mr. Most is present. He's at council table. He's seated to my left with the court's permission, Your Honor.
All right, and you are Gary Dale Most? All right, this is the time set for a sentencing in the matter. Mr. Brodowitz, is there any restitution in this matter?
1 second. Out of other than a $15 request from the Lansing Police Department for taking a sample, there's no other restitution in this file.
All right. Mr. Sarts, did you have the opportunity to go over the pre-sentence report with Mr. Most?
We have, Your Honor.
Any additions, deletions, or corrections?
None, Your Honor.
Allocution, Mr. Sarts.
Thank you, Your Honor. I'll be as brief as possible. Mr. Most is very sorry for what happened here. He's learned a tremendous amount from this experience. Obviously, he has a lot of very complicated medical circumstances. He'll follow through with all the court's orders. He has a stable place to stay. He has a loving and supportive family environment around him. He's since parted from Miss Most. They have a divorce in place, and he will work through the additional necessary legal proceedings to make sure that they keep their separation. They're no longer together and have officially divorced since this case went through. So, Your Honor, I would request the court honor the recommendations here of 1 year of Zoom reporting probation. And respectfully, on behalf of Mr. Most, I think he's an excellent candidate and he'll complete all the court's orders successfully. Thank you.
Thank you. Mr. Brodowitz, anything on this file, docket 22-03297, that was a sentencing on a guilty plea to domestic violence and brandishing a firearm?
No, the court would, or the people would leave it to the court's discretion and urge you to adopt the recommendation.
All right, thank you. So this is in regards to, as previously indicated, this is a no contest plea to count 3 domestic violence, count 4 brandishing a firearm in public. It is ordered that the defendant spend 93 days in jail beginning April 11, 2023. Credit is given for 17 days previously served. I'm going to suspend the remaining 76 days upon successful completion of probation. I will indicate that there, for the domestic assault, I will issue a fines and costs of $200 fines, $200 cost. Crime victims' rights fee is not waivable of $75. State cost of $50. That's a total of $525. And then I'm going to put you on probation for 12 months. So that will add $30 a month for a grand total of $885. So probation for 12 months. As a part of probation, you should have no contact with Connie Most or be within 2,000 feet of where Connie Most lives, works, or goes to school without consent of the court. No assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance without a prescription. Submit to random PBTs and or urinalysis as directed and paid by fees. No bars or nightclubs. You are to attend any domestic abuse therapy ordered by probation. You are not to purchase or possess any firearms. Do you understand the nature of the sentence, sir? All right. Essentially, I'm adopting the recommendation that's been indicated. You may want to go to the 5th floor and check in and make sure that they know you're on probation and to find out who your probation officer is. Okay. All right. No, and as to count for brandishing, I'm going to waive all fines and costs. So the only fines and costs will be in regards to the domestic violence that has previously been indicated.
Call probation later. That's or you can stop on the 5th floor. I'll see you.
So anything else for the record on docket 22-03297, Mr. Sarts?
Nothing from the defense, Your Honor. Thank you for the courtesy.
All right, Mr. Most, you're all set.
Thank you, sir.
Oh, I should follow JOS. I don't think I need it. I pretty much just only on that one. There's that. Where did you want to go next, Mr. Brodowitz, or? Mr. Moxley. Mr. Hess here, I saw him.
I'm hiding behind the monitor.
Are you? Are you ready on Mr. Moxley?
Yes, sir. Should we approach?
Sure.
Thank you. Well, sir.
I think we're ready to go on both 1 o'clock.
All right, let's go. I'm gonna throw you a curveball and we're gonna go on the last 2 o'clock.
Okay.
It's just a sentencing for Mr. Moxley and then. All right. So we're on the record in docket 22-00275. That's people of the state of Michigan versus Asen Moxley. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good afternoon, Your Honor. Edward Hess on behalf of Mr. Moxley. Mr. Moxley is standing to my right at the council table.
Let's say, all right, sir, and you are, and if I'm mispronouncing, Asen Austin Moxley?
Correct.
Okay. This is the time set for sentencing today. I do have a restitution information report for $188.70 owed to the Michigan Department of State Office of Financial Services. Is that correct, Mr. Brodowitz?
Looking in our file, I do not see that in our file, Your Honor.
Have you seen this?
I have not.
Do you want to?
Yes. I may approve.
Your Honor, for the record, there's no objection from the defense. That's
Okay.
the amount that was,
Just in case.
to which my client pleaded guilty to stealing.
'Cause I'll make it a part of the order.
But if there's no objection.
All right.
You have no-
All right. You've had the opportunity to go over the pre-sentence report with Mr. Moxley.
Yes, we've reviewed it.
Alrighty. Any additions, deletions, or corrections?
No, Your Honor.
Allocution, Mr. Hess.
Yes, thank you very much, Your Honor. As noted in the report, Mr. Moxley is remorseful for this behavior. He should not have used illegally somebody else's credit card information to pay for his vehicle registration. Clearly, that has resulted in all of this court process and punishment and everything else. And this is a very important lesson to him. He just no longer intends to violate the law in any fashion. I would respectfully ask that the court sentence Mr. Moxley to a term of probation so that he can prove to the court his continued adherence to the law. Thank you, Your Honor.
Thank you, Mr. Hess. Any statement you'd like to make to me, Mr. Moxley, before sentence?
Yes, just want to apologize to the court and to the victim for committing this crime. It was a few years back, but I live a different life now. I'm working on a cooking career now, so I'm heading in the right direction. I hope everyone can understand that and forgive me.
All right, thank you. I do think that this is an accurate term of probation. I read the pre-sentence investigation. This is for count 1, which is a guilty plea of larceny. So the sentence is in regards to a count 1 of guilty plea larceny less than $200. It is ordered that the defendant spend 1 day in jail, credit given for 1 day previously served. I'm going to so no additional jail time. The fines and costs on this matter are $100 fine, $100 costs, crime victims' rights fee of $75, state minimum cost of $50, restitution for $188, and probation for $360. So for a grand total of $873.70. I'm ordered probation for 12 months. That was in the probation number. So probation's ordered for 12 months. There's no use of possession of alcohol, marijuana, or controlled substance without a prescription. Submit to random PBTs as requested. No bars or nightclubs. I will order moral recognition therapy to be attended. It sounds like you're maintaining employment as it is, but I'll make that a part of the order. If that changes, just let us know. That's the extent of your order, okay? So really, it's do what probation tells you, get that moral recognition therapy out of the way, and then it's just keeping clean for 12 months, okay? If they order you to drop, go ahead and drop for them, but that's between you and the probation department, all right? Anything else in regards to docket 22-00275, Mr. Hess?
Nothing further, thank you.
All right, you're all set, Mr. Moxley, good luck to you.
Thank Probation will refer you then. Thank you. You're welcome. Thank you very much, Your Honor.
Thank you. We got done with our 2 o'clocks before we. Yeah, look, I'm not complaining.
You told me to send an email and I did.
You did. What's up next? Ms. Carter?
I believe both 1 o'clocks are prepared. I do not represent Miss Duke. I think we're gonna be asking for an adjournment to apply for public defender.
All right,
And
and I'll arraign her on the PV.
Thank you. And then Mr. Wilhart is also here ready for his PV.
Okay, so let's do Ms. Duke first. I think we're gonna put these together, okay? So we're on the record in docket 21-0249-2940. And first of all, this is set for a hearing on the date, and the hearing was really in regards to that exclusion zone that keeps popping up, because we just left, and then I have an indication that you violated the exclusion zone after you indicated to me that you were real good on where you were supposed to be and where you weren't supposed to be. So here's my take on this. I'm just gonna leave this with the new charges, okay? I'm gonna let you get your attorney on this. You know, you're entitled to a public defender. I think you should have one, but I want to work this exclusion thing out, okay? I did get a letter from the Sparrow Hospital Behavioral Health Unit, so I did get that, just so you know. But I'm gonna adjourn that hearing, and so that you can apply for the public defender's office in order to get representation. Okay, what's that?
They told me you guys had to send it, because when I called, they said that that's not what they did.
I think our clerk was not understanding what was going on.
Right, so I think that was a misunderstanding. When you're first arraigned on an underlying charge, they're right, okay? You know, it's referred over, and you get a public defender arraignment, and then if you make application, you get public defender from there on. On probation violations, you have to make the contact, and so you have their number.
Yes.
Okay, make their number, tell them, and then we'll give you the date that you need them here on, okay?
Yes, sir.
Now, so we'll adjourn the probation violation hearing.
Okay.
So we'll adjourn the PV hearing for representation purposes, and you're gonna seek representation from.
And I'm actually, after we're off the record, Your Honor, I'm gonna complete that application for myself.
All right. And if you're gonna do that, a week should be enough, don't you think?
We still have to get all the information from it. I would ask for maybe 2 weeks.
Okay. I am, after we do this.
Okay.
Yeah.
I'm sorry. I was. April 25th at
Your Honor, I don't know if it's a little unusual. She's asking me with her work schedule, is it possible to have a hearing in the morning as opposed to the afternoon?
Doesn't matter if you're here.
I'm here. I don't
Yeah.
mind it, yes.
Yeah. Do we have anything, what's April, that's just a, is that just a?
Tuesday, I believe.
Yeah, it's a statute day, so it doesn't matter to me. It may matter to probation though, if they have to be here, because they're not normally here in the morning.
Right, and I'm not sure. I know there are departments in the building, so I don't know if they're
Right.
available. I'd like her not to miss work if at all possible.
Well, let's set it for April 25th in the morning. 9:30 is good.
Thank you.
So April 25th at 9:30. And in relation to also, we have a PV arraignment that we have to do. And this will be part of that. So so I'm going to indicate the charges that have been brought against you in regards to violation of your probation. And this is in regards to request and summons for probation violation signed by your probation officer, Jody Bayless, countersigned by the court. And it alleges that on March 30th, 2023, defendant displayed assaultive threatening behavior on March 20th, 23, left 5 inappropriate and aggressive threatening voicemail messages for this probation officer. Those have all been recorded. So if council wants to hear them, I know that they're all recorded and I have not listened to them, but I'm willing to, okay? So those are the charges that have been brought by the probation officer. Those messages are intact. I made sure that they were intact. We are going to set that hearing for the same date. So we'll make it so April 25th.
And Your Honor, I did want to advise you. I've had a brief conversation with Mr. Brodowitz. He believes this might represent a conflict of interest for my office. We may be seeking conflict counsel.
Okay.
For those violations in particular, just kind of wanted to forecast that for the court.
All right. All right. Just let us know, but we're setting it at the same time, April 25th at 9:30 at the same time, in regards to that violation. And then we'll go from there. I do plan on April 25th, if the probation officer, we would have those recordings available for anybody to listen to, okay? All right. Anything else for the record in docket 2102-940, Ms. Sutter?
No, Your Honor, thank you.
Anything, Mr. Duke?
No, sir.
All right, we'll see you here back on April 25th at 9:30, okay? Then Mr. Wilhart?
Yes.
All right, so we're on the record in docket 21-02793. That's people of the state of Michigan versus Cecil Wilhart. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Wilhart, who's standing to my right.
And sir, you are Cecil Wilhart, is that correct?
Yes.
Okay. This is the time set for a probation violation hearing. Ms. Sutter, how are we proceeding today?
Thank you, Your Honor. At this time, we do not intend to contest the violation. Mr. Wilhart would accept responsibility for it, and if I may be heard on the recommendation.
All right. So you understand, sir, that it's my understanding that this is only in regards to one violation. The other one's been dismissed.
Correct.
That the request is that it's my understanding you are going to admit responsibility to the violation in regards to the violation of your probation, and then we're gonna go right to sentencing. And there is a recommendation, and I'm going to allow your counsel to speak on that. Do you understand that, sir?
Yes, sir.
All right. So I'm going to have you raise your right hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury. All right. It is alleged that on January 10th, 2023, you failed to complete outpatient substance abuse treatment per cognitive consultants, and you were unsuccessfully discharged on January 10th, 2023. As a condition of your as a technical condition of your probation, how do you plead to that allegation that you did not complete outpatient substance abuse treatment successfully?
I'm guilty, I didn't.
Okay. All right. With that understanding, that is so defendant admits to the only violation, the previous one was dismissed, admits to violation number 16.
Yes.
Yeah, that's how they have it.
Yeah,
Number
I-
16.
It was 6 in my head.
Okay. And Ms. Sutter, would you like to be heard on the recommendation?
Yes, Your Honor. By and large, as the recommendation itself exists, we would ask the court to follow it. Ms. Bayless has recommended an extension of 3 months for Mr. Wilhart to complete the outpatient treatment with cognitive consultants. He's been in communications with the past of them. I don't know how much of it the court has been able to read, but there has been some communications where he's trying to get himself back into treatment and trying to make payments, and looks like some difficulty with their payment system that he's trying to get addressed, and as well as waiting for today to kind of resolve and make that payment to them to get back involved with their programming. So he's fully willing and engaged in completing that process. What I'd specifically like to speak with the court about is back in January or end of last year when we were here, Mr. Ledesma advised that he be put on a scram tether. That was something I believe he did on his own, given some issues. At that time, I think Mr. Wilhart was advised that'd be for about 30 days. Mr. Wilhart's still on that scram tether. He's also doing monthly testing at PETS. Given that he's already testing and I have not seen any violations regarding positive results or positive scram tethers, I would ask the court consider removing the scram tether at this time and allow him to just continue doing the testing he's doing at PETS while completing the remaining portion. Adams, thank you. While completing the remaining portion of his probation.
All right, and the recommendation is to extend probation 3 months.
Right, to complete the outpatient treatment. So I suppose my request is a little off the pink sheet.
Right, but that would be his probation end date would be in June then, right?
It would now be in June, yes.
Okay. All right, well, I think that's a fair request. So I'm going to adopt the recommendation and add, but for our purposes, to strike or not make a part of the order. So I'm not ordering scram testing at this time.
So I can safely advise him that he can have that removed.
Yeah, he can have that removed.
Thank you.
And then we're following the recommendation, which is outpatient cognitive consultants treatment. You're to test 1 month at AberHealth. I've got costs right now at a current balance of $505. The last payment was made on February 23rd for $60. You want to keep that up, okay? I'm going to extend probation for 3 months. So your probation will be in order to finish the outpatient, it's going to be extended 3 months to June 17th. In the interim, you're to complete your outpatient at Cognitive Consultants. It's left in the court's discretion, jail time. I mean, it literally says court's discretion. You know, don't give me a reason to put you in jail. All right, that's all I'm asking you, okay? Because I'll do it, okay? But if you don't show up or if you don't complete the Cognitive Consultants outpatient, if you don't do what you're supposed to do and get this behind you, you're not a kid, you know, then you leave me to no choices. And the one choice I have is, well, I know in jail, you're not going to have the opportunity that some of these other opportunities are going to give. That's not helpful to anyone, right? I mean, the big key right now, as you know, is to get through that outpatient to get this behind you. All right. So let's do that. Okay. Do you understand your sentence? Do you have any questions concerning this probation violation?
Yeah.
It's really the outpatient, extend this and your testing. Those are the three. Keep your balances current and let's put this behind you. Okay.
Yeah.
All right. Anything else for the record? Docket 21-02793, Ms. Sutter.
No, Your Honor. Thank
All
you.
right. Thank you. We're all set.
No, so he will go in the file and then click send it out.
I'm trying to write that.
So
I
they're
just
getting-
don't know.
I would recommend.
No.
Would you like to-
Could you have Mr. Brodowitz? Or we can do Miss Hill?
We've got.
Yeah, no, good luck to you.
That one's right.
Yeah, I put it on the top. It was remove screen.
Okay. I think I know we're ready on Williams at 1:30.
All right, let's do on Tyrese Williams. All right, so we're on the record in docket 22-03588. That's people of the state of Michigan versus Tyrese Williams. Will the parties please indicate their presence for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
May it please the court, David B. Carter Jr. on behalf of Tyrese Williams, who is present and standing at council table.
And sir, you are Tyrese Williams?
Yes, Your Honor.
All right. This is the time set for a sentencing in the matter. Mr. Brodowitz, is there any restitution in this case?
I believe there's none.
I don't see any. I'm just double checking.
No, I
Okay.
do not believe so, Your
All right. Mr. Carter, you had the opportunity to go over the pre-sentence report with your client?
Yes, Your Honor.
Any additions, deletions, or corrections?
I would like to update, I guess that's
All
a
right.
fair way to say, employment data. My client now has a job at Ryder as a high-low operator.
And how many hours is he working there?
Full-time.
Full-time. All right, allocution, Mr. Carter?
Thank you, Your Honor. Your Honor, this is a sad state of affairs that Mr. Williams is in front of you and he recognizes that. There's no secret that he's got some issues. He's on probation when this occurred. He is married to Tiffany Williams, who is present inside the courtroom today. I've had an opportunity to discuss with her. I've also had the opportunity to discuss with her regarding the no contact order that the probation department wants to continue. And it's my understanding she would like to have that lifted. They are married together. They are married and they would like to be together. I asked her, well, do you feel safe? Do you believe that you're in danger or anything like that? She indicated no. Again, the court can talk to her at the right time for that issue. I would indicate to you that Mr. Williams is definitely taking this case extremely serious. He's embarrassed that he's before your court. He's also embarrassed that he laid his hands on his wife. He understands that he needs to make better judgment decisions when in very stressful situations. I stand here before you today as Mr. Williams' attorney, but throughout this ordeal, I've acted more as a counselor with him and stressed how important it is to get fully engaged in services because they're going to teach him what to do during stressors, because that's the plan. You got to have a plan going in so that when those stressors hit, you understand what to do before that. As you know, it's very bad to try to figure out a plan during the time the stressors hit. You make poor judgments, and that he realizes. Mr. Williams believes that he can be successful on probation. He's also explained to me that he's tired. He's just tired of being in the system, and he does want to change his life. He's a father and he wants to start being more of an example for his children. And with that said, we'd ask the court to follow the recommendation. We'd ask the court to lift the no contact order. It's also my understanding my client does have a GPS tether. We're asking that to be removed today. He's been on bond since this ordeal for nearly 3 months now. I don't believe there's ever been an issue with a probation or a bond violation before your court. I think that shows this court that Mr. Williams is serious, and he is now at that point in time in his life where he wants to turn that corner and become more of a productive citizen. Thank you.
Thank you. Miss Williams, are you here? Tiffany Williams? All right. Did you have the opportunity to speak to probation in this matter? To anybody concerning the pre-sentence report, there's an indication that you were mailed a questionnaire by the probation department, and then they didn't receive a response. So, okay, all right. So, did you have anything you wanted to say to me?
I feel safe and I want my husband back.
Okay. Well, this creates an issue with the domestic violence second. You understand that, all right? So this is what I'm willing to do today. So thank you. I understand your position. This is what I'm willing to do today. This is for count 3. The sentence is to count 3. Mr. Williams, do you have anything you want to say to the court before the court passes sentence? I thought Mr. Carter was set it up pretty nicely for that.
Yes, Ron, I just want to apologize to the court. And one thing Mr. Carter didn't mention, I had buried my father on the 8th on Saturday, and it's just been hard. My father had overdosed and was left in the parking lot. I just wanted to say sorry, and if you guys give me a chance, I'm willing to do everything I'm supposed to do.
So this is for the guilty plea of an attempt R&O count 3 and a domestic violence second count 4. I am going to follow the recommendation as it's been indicated, except for one thing, and this is to have Miss Williams involved in this. All right, but I'm gonna suspend jail for 365 days beginning April 11th. Credit is given for 2 days previously served. And I'm going to suspend the remaining 363 days. There's 2 1-years here. They're the attempt R&O and the DV2 upon successful completion of probation. Okay, so we're good. We're good with that. So if it sounds like I have something over your head, I have something over your head. Okay, I mean that goes without saying. I'm not worried about you. You're going to be on probation for 18 months. I'm not worried about you for the next 18 months because if you have a problem with probation, you have a problem with me, and I can end this probation by just putting you in jail. That doesn't answer any of the problems that we're going to solve here. Okay, that doesn't do anything for our good choices. If you embrace this probation and you learn from it, and it's going to be difficult at times. But then maybe a year or 2 or 3 years from now, when you have to make a good decision or a bad decision, you'll make a good decision and you won't spend any more time with me. That's what we're trying to avoid, right? Yes. And that's the heart of district court is to getting you so you don't come back here, or that you don't graduate to circuit court, right? You don't want to do that either. No. None of those are good ideas. What we want to do is kind of finish it up here, and I know that happens. So on these 1 years, you're going to have some fines and costs, okay? It's $200 fine, $200 costs in regards to the attempt R&O, $75 crime victims' rights fee, $50 state minimum costs, and then I'm going to put you on probation for 18 months. So it's 400 plus 75 plus 50 plus 540. That's on the. So that's a grant. That's a total of 1,065. And then on the domestic assault, $200 fines, $200 costs. I don't have to reiterate the crime victims' right fee. There's a state minimum cost of 50, and I don't have to reiterate the probation fee. So that is 50. So that's $450 on the domestic assault too. 18 months probation. I'm going to abide by the no contact order with Tiffany Williams for the first 60 days. All right, for the first 60 days, just to get you in your intensive domestic violence processing. Okay, because this is a second offense, and so I have worries. Okay, I have worries for, and we tend to hurt the ones we love the most. Okay, that just tends to be how it happens. We want to avoid that. So after 60 days, what I'm going to have Ms. Williams do is contact probation, indicate to them, this is where I stand, this is what's going on. But right now, I'm keeping the no contact order in place until I hear from probation and until we get some involvement in the intensive domestic violence. All right. I am removing the tether. Okay. So that's a part of this. So CJOS, but I am removing the tether at this time. But there's still the no contact order. So if you get caught and you're within 1,500 feet, 2,000 feet of Miss Williams, there's going to be a problem. Okay. No assaultive or threatening behavior, no use of possession of alcohol, marijuana, controlled substance without a prescription. Submit to random PBTs and or urinalysis directed by the probation officer. No bars or nightclub. I'm going to, as a part of this, it's 18 months. So moral recognition therapy, that can be done at the end of it. I'm more interested in involving yourself in the intensive domestic violence program. All right. I think that is a big deal for this. All right. That shows me that you're owning up and taking responsibility for your actions, and also that you understand that your decisions you make are going to, especially in domestic violence, are going to affect the people around you. And that's what we're trying to avoid, right?
Yes, sir.
Obtain, maintain any employment. You seem to have done that. And as a part of the probation order, not purchase or possess any firearms, ammunitions, or weapons of any kind. Do you have any questions about the probation? Oh, you just wrote in the, okay. Do you have any questions about the probation sentence or the sentence that I've indicated?
No, Your Honor.
So I'm going to put on here 60 days, no contact, and then we'll revisit, okay?
No, we'll get a judgment today.
Yeah.
I'll get that.
And we'll release you from tether, okay?
Yes, sir.
As a part of this. And then we'll revisit the no contact issue in 60 days. That's just to get you involved in the domestic assault therapy. So the one thing I can't have you do is I can't have a repeat because we're running out of options. All right. We just are. All right. Mr. Carter, do you have anything?
Do you want me to schedule a hearing in 60 days?
No.
Oftentimes I'll get a family member such as Miss Williams contact me because she knows I represent him. Is it okay if I initiate that? If
Absolutely.
There's no issue?
It is. I don't have any issue with that at all. All right. As long as it comes within 60 days for a closer look at this.
Okay.
Then probation's in contact with me and then we can make a decision on it. All right.
Thank you.
Oh, thank you, Mr. Carter. Anything else for the record in docket 2203588? Mr. Brodowitz?
Nothing from the people. Your
Mr.
Honor.
Carter?
Nothing.
All right, you're all set. Good luck to you, Mr. Williams.
Thank you.
Let's do Mr. Rothstein, are you ready?
Yes, sir.
All right, so we're on the record in docket 2202304. That's People of the State of Michigan versus Alyssa K. Hill. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Jeffrey Rossing on behalf of Alyssa Hill, who is standing to my right.
And ma'am, you are Alyssa K. Hill?
Yeah.
All right, this is the time set for a sentencing in the matter. Mr. Brodowitz, is there any restitution in this matter?
There is not, Your Honor.
Okay. Mr. Rothstein, have you had the opportunity to go through the pre-sentence report with your client?
I have, Your Honor.
Any additions, deletions, or corrections?
One deletion, Your Honor. It says in the report here that this pending charge is open intox and 54B. That is all taken care of, and she's been sentenced to fines and costs. Other than that, everything else looks good.
All right. Allocution?
Your Honor, I've been with this case for a while, and I think when Alyssa Hill came back before us again after failing to appear. She's a totally different person. 22 days in jail did her a lot of good. I know that she is committed to not drinking any alcohol and following the rules of her mother. I've been in contact with her mother several times. She is now, there is no incidences in which she hasn't listened to her mother and done what her mother told her to do. Obviously, if that was the case, her mother has told me that she wouldn't be allowed to. So Alyssa has made tremendous progress since the very first time we were here, but even since since the conviction. She does have another case in 55th, but she's on a scram tether. So I would suggest that submitting to random PBTs or urinalysis is kind of double. Otherwise, I think the recommendations are absolutely fine. I would hope that you do give her an opportunity to earn her HIDA status. She is unemployed right now, so I'd ask you to limit fines and costs as much as possible. With that said, again, I think the recommendation is a good recommendation and that we follow it. Thank you. Other than the random testing.
All right, thank you. Ms. Hill, is there anything you'd like to say to the court before the court passes sentence?
No.
Okay. This is for count one, a guilty plea to attempted, the sentencing is for count one, guilty plea of attempted resisting and obstructing a police officer. I've looked at the pre-sentence report. I believe it to be fair and accurate. I don't have any problem. You're already on somewhat probation to 55th on some level. So I don't want to duplicate that. But I'm going to follow the recommendation. The recommendation is spend 22 days in jail beginning April 11th. Credit is given for 22 days previously served. So credit is given for that. I'm going to hold 30 days upon successful completion of probation in this matter. The fines and costs on the attempt R&O will be $200 fines and $200 costs. Crime victims' rights fee that I can't waive of $75, state minimum cost of $50, and then a probation for 9 months as requested, for a grand total of $795. I'm going to put you on probation for 9 months. Okay, that's $30 a month, which is at part of that $795 total. There was no objection to YTA if you fit the status, and we're going to get you through probation if you fit the status. Okay, and that I think that's probably the biggest carrot. I think. Okay, it appears that you've made every good decision recently. Yeah. And so I want you to continue that. It's so important to continue making good decisions on here. Oh, the 9 months, extra 9 months. If you make bad decisions on that, I've got jail time to hang over your head. Yeah. But I'm more considered. You're a young person. I'm more considerate about you. I'm more concerned about you 3 or 4 months from now, 3 or 4 years from now. Okay, when you have to make good decisions and you want to get out of this district court cycle, and you want to do things that you're proud of. All right. So I'm going to order no assaultive, threatening behavior over the 9-month period. No use of possession of alcohol, marijuana, controlled substance without a prescription. It's my understanding you've adopted that lifestyle. No bars or nightclubs. I'm going to strike random PBTs. So I'm going to strike random PBTs. As duplicative. You can moral recognition therapy, complete that sometime during the next 9 months. Okay. Probation probably wants you to get it done quicker. Okay. Obtain and maintain employment and not purchase or possess any firearms. Do you have any questions about the nature of the sentence in this matter? No. All right. All right, Ms. Hill, you're all set. Okay. Okay. Thank you.
Thank you.
Thank you, Mr. Rothstein.
Man, does she need to go by the probation?
Yeah, she should go and just check in. I have two more files, Mr. Brodowitz. We have a Mr. Jones who needs to be brought up. And then Mr. Perry Johnson.
Yeah, I do not know who represents.
All right.
Mr. Perry Johnson.
I don't know if is there a Mr. Perry Johnson in the courtroom?
When you were in on the weekend, we had a whole tri-county.
Yeah, this is, I don't know where he is.
Let me see if I can-
Do we know where he is?
Yeah, let me see if
What I have in our system, Miss Sutter is assigned attorney. So I'm not sure, she's probably gone by now, but
I don't think we've seen him in.
I also have an email from earlier today from Mr. Milks on, I believe it's felony matters for later this week. So I'm not sure who's representing him currently.
So he has what, a PCC or preliminary examination later in the week?
He has two PCCs on Thursday.
In front of
you.
Well, let's
Mr.
hold
Milks
this
is on
until
one of
then.
them.
Yeah, because I don't think he got my accounts on this because it's for the probation violation hearing and you would have to make application to
Yeah.
the public defender.
I think we've just lost track of him.
Okay.
And Vineland gives him cooperation. I don't know where he is, but he's not here.
All right, so
You want to just me to hold it for
yeah, let's
Thursday or
set
Friday, whichever day it is.
set for. Is it a PCC or a prelim?
The PCCs on Thursday.
Set for PCCs on. That would be the 13th.
Just set it at 8 different PCCs.
Yeah. Let's see if we can clean it up then. At 8:30. All right. Then we'll do Mr. Jones, and then we should bring in the jury.
The 13th at 8 or 8?
Yeah, at 8:30.
Yeah.
There's a PA 53 set.
Yeah, I believe our detective is out in the hallway. So.
Oh, it's the program at the jail. I'm sorry, Judge. That was on their recommendation.
Yeah.
So I had to look. And I'm sorry about the other thing. Mr. Alford did go down to probation. He just failed to appear for Zoom hearing.
Right, that's okay. I mean, it's just,
They just don't.
he's, if he doesn't show up and I don't have a report, I don't have a choice. I mean, you know, they'll have a bench word out for him and, you know, I just don't know what to do with him right now. And he's over Zoom, so we can't remand him, no. You know,
You can do is put that on warrant.
exactly, that's right.
That's allowed?
Yeah. That's exactly right.
But he was, he didn't feel like he was
Right.
Zoom.
But this one didn't set
And
anything.
he says they failed to appear for the Zoom appointments.
Because your
I trust them more than him, but we can't have a hearing because, you know.
And it was, I
So
think,
if you guys want to stipulate. just handle the charges resulting
organized.
from this, then I
If
can
it was
counsel on
Mario,
that. Just go ahead and submit it.
both of those two.
So basically, it'd be that you know, my request would be additional proceeding to release people.
Which one?
Deal that we had for Pfeiffer.
Yeah.
But then
Trying to give you
pipeline.
Right.
judgment so that.
Oh,
there's
this
no-
was one, okay, yeah, this would have been one of Mr.
It's
Pfeiffer's.
not as much.
After we were done, we did.
Yeah.
If you want to extend that offer,
No,
then we can probably just have them admit to the call, just get this done with. You guys can bring the jury.
I'm gonna try to see.
Okay. Well, they're bringing them up. Mr. Sartz, did you need a second with your client?
No, we should be ready to go, Your Honor.
Yeah, we moved that just, we're supposed to see him Thursday. For PCC, so we just, he's not here and his attorney's not here.
Okay.
So but I'm gonna see him, I'm gonna see his lawyer Thursday with him.
You can hang on to that.
Yeah, so we're gonna see.
I was just a little confused. It's like, wait a minute.
Yeah.
Okay, all right.
I'm gonna see if I can wrap it all up when I see him on Thursday.
Thank you very
You're
much.
Well, this sentence, we don't,
No, it was a section of 53.
there's no restitution on this case. Oh, but there's a P53
And I
violation.
think he said that, I saw it detective say shop. I don't know if that's the detective. Is that there?
All right. So, Mr. Brodowitz, are you ready on Mr. Jones?
One second.
Okay.
All right, yeah.
All right, we're on the record in docket 22-00887. That's people of the state of Michigan versus Jeffrey Jones. It's time set for sentencing. Will the parties please introduce themselves for the record?
Jeff Braddock's on behalf of the people, Your Honor.
Good afternoon, Your Honor. Jacob Sartz, the fourth assistant public defender here on behalf of Mr. Jones. He's at council table. He's standing to my right.
Sir, you are Jeffrey Jones?
Yeah.
All right. This is the time set for sentencing on the matter. Is there, and there's a PA 53 that's along with Mr. Jones. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. At this point, after conversations with defense counsel, the people have made an agreement that Mr. Jones will plead to the PA 53, being that he did have contact with the victim in this matter. In exchange, the people have agreed to not pursue any type of witness intimidation or witness tampering charges up on any conversations up to today's date, which would be April 11th. April 11th, 2023.
All right. And what is that, for your understanding, what is the penalty that Mr. Jones could receive on a PA 53 admitting to the PA 53 violation?
Be up to 93 days in jail, Your Honor.
That's my understanding.
PA 53, correct, yeah. Thank you.
All right. Is that your understanding, Mr. Sartz?
Yes, Your Honor.
All right.
I had a brief opportunity to explain that to Mr. Jones. Certainly, we're concerned about the possibility of witness tampering in light of these allegations, but I believe this is perhaps a good pathway forward to simply resolve this.
All right, thank you. Mr. Jones, you understand that the maximum penalty for a violation of the PA 53 or no contact order is 93 days in jail. Do you understand that, sir? Okay, it's my understanding you wish to plead responsible or guilty to a violation of that order. Is that correct? Okay, I'm going to bring your attention back to the violation itself on the PA 53. Find that. So it was ordered that you were to have no contact, direct contact or indirect contact, be within 2,000 feet of the victim that works, lives, or attend with the Jamelia McCoy. Is that correct? And it's my understanding that on February 23rd, there was phone contact, at least phone contacts made by yourself indirectly or directly to Miss McCoy. Is that correct? Okay. And that you understand is a violation of the PA 53 and the no contact order. All right. So the ultimate penalty there is for 93 days on so I'm going to hold that and let's do the sentencing and then we'll get back to the 93 days. Okay. All right. So the case is docket 22-00887 and Mr. Sartz, have you had the opportunity to go over the pre-sentence report with Mr. Jones?
We have, Your Honor.
Any additions, deletions, or corrections?
None to the report, Your Honor.
All right, allocution.
Thank you, Your Honor. Despite how the probation officer believes that Mr. Jones came across initially, Mr. Jones is very sorry for what happened here. You know, he has learned a tremendous amount in going through this process. He does have an active plan to work on some of his underlying mental health issues and his struggles with anger, Your Honor. He has successfully completed CATS, the men's group. He's also been involved in the self-study Bible courses with Forgotten Man's Ministries. He's been active in that. And he has further plans, Your Honor, to attend anger management counseling. And he's doing it right now, actually, through the jail, Your Honor. And Bridges as well, Your Honor. So Mr. Jones, to his credit, has been trying to better himself since he's been lodged in jail. As Your Honor's aware, he's serving a sentence right now. He's also involved in a breakout class as well, Your Honor. So Mr. Jones, to his credit, has been trying to rehabilitate himself, has been participating in the programming that's available to him through the jail. Right now, he's under sentence from another matter, but he is using his time productively. He is, trying to grow from this, learn from this, and he's very sorry for what happened here. The recommendation is 180 days. We originally had a sentencing agreement that was part of the deal. You know, certainly, Your Honor, that the prosecutor could request that be set aside, but respectfully, the 180-day recommendation is certainly within reason. Even if the court was inclined to grant that request, I would request the court just give him 120 days with the 115 credit and have that be served concurrently with any imposition of sentence related to the PA 53. And Mr. Jones is going to be sentenced in front of Judge Jamo in several weeks. He will be certainly looking at either some type of felony probation term possibly, or some other sanction along those lines by Judge Jamo on April 26th on a malicious destruction of property case, which we resolved. He will be expected to pay some restitution. So he is, Your Honor, certainly not walking away from this scot-free by any means. He's currently under sentence. He's been in custody now continuously for a long period of time. And further, Your Honor, he is, potentially going to be facing additional sentencing from Judge Jamo before the end of the month. So respectfully, Your Honor, I would just request that the court give him 120 days credit for 115 and also a concurrent credit for time served sentence as it relates to PA 53. Thank you.
Thank you. Mr. Radovich, do you want to be heard on any sentencing?
No, the people would just urge you to adopt the recommendation. We would leave it to the court.
All right, Mr. Jones, is there anything you want to say to the court before the court passes sentence?
I just want to say, I'm really sorry for this incident, and this time being in jail, the breakout program let me see that I need to own up to my mistakes. And I'm glad that when I do get out, I can finish that in the world. So like if I don't finish it, she set me up so I could go to the world and finish that. So I like that program.
All right, Mr. Jones, I wish more probationers could see this because you've left me no options but to sentence you to jail. It's just a matter of how much. Okay. This is for count one, a guilty plea to domestic violence in the second degree. In the second, I'm going to adopt the recommendation, spend 180 days in jail beginning April 11, 2023. Credit is given for 115 days previously served. I'm going to waive fines and costs in this matter. So our crime victims' right fee of 75, state minimum cost of 50 for a total of $125 that probably we can administratively close, I would think. So under the sentence, I'll follow JOS and adopt the recommendation and administratively close on fines and costs. I'm going to take the 93 days and have that run concurrently with whatever sentence you're currently. So that will run concurrent with your last. So you'll get time served. It's a let's see, 25, 35, 45, 55, 65, 75. Yeah, that's 65 days plus 30 more. So 93 days to any part of that will serve concurrently. With your present sentence. But I am adopting the recommendation. While you're in jail and serving the rest of your time, it sounds like you've taken part in the restorative justice program. So you're already doing that, all right? Good luck to you, Mr. Jones, okay? Your time here is done, all right? All right, thank you.
Thank you.
There's none.
Yeah.
Your Honor.
Yes.
He still has his phone privileges blocked.
Yes, he does. In relation to the victim in the matter, if he's got family members or such, any type of reach out to family members while incarcerated, that's not a part of the order.
Okay.
Just as to the victim.
Thank you, Ryan.
What did you need?
That was it. I made a new one.
All right.
53 cents on that. And just, like I said, I'm not.
All right, we can come back up with our jury trial.
Vacate the chair.
20 minutes longer than we. Yeah, you can run. If we can't grab the jury, I do it now. What do you need to do in probation?
They just, Nathaniel just asked me to bring this down.
That's fine.
Oh, they need to do. I have.
All right. So when Nathaniel gets here and Wendy gets back from probation, we'll get on the record.
Is there anything they need to do outside the presence of the jury?
I don't have a prosecutor, so I don't know.
Oh, I thought he was still there.
So when do you get a break?
Today? Sometime this afternoon?
That was not in the job description, was it?
Mr. Ring, did you have anything to put on the record before we start with additional witnesses?
I have nothing to put on the record, Judge.
All right, so go ahead. Yeah.
I'm
I'm just making sure she can get down to probation, so.
No, I have nothing to put on the record, Judge. You didn't get lunch, did you?
I got a little bit of that.
Isn't that why you have a clerk? Isn't Nathaniel bringing you stuff?
He wanted to get lunch too.
Yeah.
Yeah, he didn't get it either, did he?
Oh, he did.
Yeah.
Oh, did he?
Yeah.
Well, Judge Ward's court's flooded.
Is Judge Ward's court flooded?
It's flooding from the ceiling.
That's what I saw when I got off the elevator.
They've got tarps down to stop it. The defense counsel table had standing water in it.
You know, this trial is supposed to be in Judge Ward's court. They're supposed to replace our benches.
Yeah.
And we're supposed to be in Judge Ward's.
Wow.
Yeah,
So everything good happens for a reason, I guess, right?
So what happened in Judge Ward's court?
It's flooded.
There's a water leak somewhere in the
There's a
ceiling.
water leak.
And it's like dripping down from the ceiling in different spots, like 4 or 5 different spots. One of them's like right between the 2 cameras.
They were supposed to replace all the benches you're sitting on this week. And I was supposed to go to Judge Ward's court, and the installers had all kinds of problems, so they didn't replace them. So that's a good thing, I guess, right?
Yeah.
We have the installers to thank for not being wet.
Right. Well, the millage passed, so otherwise I would say alert the media.
You-
Get him here to take pictures.
Right.
Come on, it's gonna be in the 80s this week. You got a
Look.
built-in slip and slide over there.
Yeah. I mean, they've got everything tarped up and protected.
They've been talking about replacing this business since you and I were young lawyers.
Yeah.
So, you know.
very, very long ago.
So maybe in our lifetime, we'll see a new district court.
Something where you get a little temperature control.
Temperature control in a courtroom that's not flooded and walls that are not paper thin.
And a little bigger hallway.
Maybe some conference rooms where you actually can meet with your clients other than the stairwell, you know?
Room at the council
I
table.
take, there's that little picture from the wall back there. When I have to do Zoom, I take it and I put it behind me to make it look like I'm in an office.
Long list of requests. And now both the prosecutor, Mr. Stevens, and the public defender, Mr. Milks, have gone down this back door, which locks when you close.
Oh, no.
Which means that they can't get back in.
I thought Mr. Feigl.
So they actually, Mr. Feigelson also did that. Yeah.
That's great.
Mr. Stevens said that he did that, and so they Zoom for us to go back and let him in. I don't know what to say about that. I really don't.
Oh, good thing we didn't need Judge Ward's courtroom.
We were just laughing about that.
It's
That could be us.
I was on the elevator when the maintenance guy was like running up. He's like, we're going up, hurry up, hit the button because I need to get, we're just flooding.
Well, when we thought we were gonna be there yesterday, I pulled up Miss Obenauer's recording equipment and it had this horrible sound on the line. Like, I wasn't sure we'd be able to do an exam in their sound.
It was like the water is dripping like from right between the 2, one spot's right between the 2 cameras that face.
Yep, but explained all the buzzing.
That's not to say that our recording equipment's any better.
Right.
No, it's
Evidently.
not. It's actually the same recording equipment, just every room's wired a little different.
Addie will have to stop over there occasionally because Addie's got, her computer just shuts down.
That's.
When did you want this back?
Yeah. Actually, I'll take everybody's back, please. Do you all have the jury?
I gave mine to Jason. I gave mine in Parker's to me.
That's mine.
Okay.
There's Jackie's.
Mr. Nickel, did you have one?
I gave actually Parker's to Nathan, then I gave mine
Nathaniel?
to the person whose name the judge could not remember this morning.
Miss
Miss
Susan.
Kneeling,
Yeah,
okay.
Miss Kneeling.
Okay, thank you. Do you have yours?
My what?
Your jury.
Somewhere. Somewhere around here. Maybe on my desk.
Mine's from right now.
Here it is.
Thank you.
All set. We're ready.
All rise for the jury.
All right, you may be seated. Hopefully everybody had a nice lunch, okay? We're back on the record, 23-00011. Mr. Ring, you may proceed with your next witness.
Thank you. The people call Officer Ethan Mertler.
Hey, Officer Merlick, I'll have you stand right in front of me. State your first name and spell your last name for the record.
First name is Ethan. My last name is Merlick, M-U-R-L-I-C-K.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Right, please have a seat and please project for recording purposes, Mr. Ring, when you're ready.
Thank you, Judge. Officer Merlick, where do you work?
I work for the Lansing Police Department.
How long have you worked there?
Almost 10 years now,
What capacity do you work?
as a road patrol officer.
And were you working as a road patrol officer on January 2nd of 2023?
Yes, sir.
And at some point, were you dispatched to 2400 Northwest Avenue?
Yes, sir.
Is that in the city of Lansing, County of Ingham, state of Michigan?
Yes, sir.
And why were you dispatched there?
We're dispatched in reference to an assault complaint.
Were you the only one? Were you the only one on scene when you arrived?
No, sir.
Who was there when you arrived?
Officer McGregor was first on scene.
And what did you observe when you first arrived?
Upon arrival, I witnessed Officer McGregor speaking to a female seated in a silver four-door sedan.
And did you speak with Officer McGregor before you did anything?
We made brief contact. He just pointed to the female in the car, and that's why we began speaking with.
And you spoke to that female in the car?
I did, yes, sir.
And did she identify herself?
As Valerie.
As Valerie?
Strauss.
Is it?
Same way.
Yeah, thank you. And so did you talk to her during that period?
We did, yes, sir.
And did she tell you if anything happened that day?
We had a conversation about why I was there. I informed her I was there to investigate some sort of alleged assault. And she informed me that there was no assault occurred.
And what was her demeanor when you were talking to her?
She was seated in a car. I would say she was calm.
And is Valerie Ostrowski in this courtroom today?
Yes, sir.
Can you please point to her and describe something she's wearing?
Off to my left here in the black and gray stripes.
Let the record reflect that the witnesses identify the defendant.
Any objection, Mr. Moss?
No objection.
Without objection, the witnesses identified the defendant.
And so after you took her statement, what did you do next?
Officer McGregor came in and spoke with me.
And what did you do to speak about?
He advised me that the victim was claiming to be assaulted.
And what did you do next?
Officer McGregor and I advised Valerie of the assault and that she'd be under arrest for assault.
And did her story change at that point?
After we advised her that she was gonna be under arrest for assault, she advised there was a struggle on that. The victim grabbed and twisted her arm.
And did you do anything after that?
There was no other follow-up statement. Nothing else was made after that initial statement she provided to us.
Did you interview anybody else while on scene?
Yes, sir.
Who did you interview?
I interviewed, it would be the grandmother of the victim, mother of the accused.
And was that before or after you and Officer McGregor had spoken?
That was accurate.
And when interviewing the defendant, did you notice any types of injuries?
No, I didn't notice any injuries.
Even after she said her wrist had been grabbed, did you notice any injury?
Negative. She held her arms out briefly and there was no sign of a fresh injury.
No further questions this time, Your Honor. Thank you.
Cross-examination, Mr. Moss?
Yes, Your Honor, one moment, please. Good afternoon, officer. You were not present when the alleged incident occurred between Valerie and Rachel. Is that correct?
That's correct, sir.
And you wrote a police report regarding that incident,
Yes, sir.
and your reports are accurate and thorough.
Yes, sir. They're just a summary of the events that occurred.
And when you arrived that day, you were wearing a body cam and it was on.
Yes, sir.
Did you review your body cam footage in preparation of your testimony this afternoon?
Yes, sir.
Your Honor, at this time, I'd like to show the witness defense proposed exhibit M.
All right. So this is the defense proposed exhibit
M,
M.
Your Honor.
Okay.
What you're trying to do violates the court rule. You can't do it that way. You have to you need to work that out that way. You can't do the objection to that person, especially eviction from law correction, okay?
Sorry, do you recognize this as your body cam footage from that day, officer? Yes, sir. You have any reason to believe that this footage has been altered since the last time that you saw this footage? No, sir. Your Honor, this time, defense moves to admit proposed exhibit M into evidence.
Any response to admission of people's proposed exhibit M?
Defendant's proposed exhibit.
Defendant's proposed exhibit.
No
M.
objection, Judge. Thank you.
Okay, without objection, defendant's proposed exhibit M is admitted into evidence.
Your Honor, let the record reflect beginning, I guess I'll begin publication at 40 seconds.
All right.
Hi, I'm Ethan. I'm with the police department.
Hi. Can I ask why the creepy old neighbor is sitting down there and calling the cops when my daughter and I are fine?
Oh, I got no idea what
That
they're.
gray van, he used to live 2 doors down,
Oh.
and he's just been sitting there.
Oh, people are nosy. Everyone
Yeah,
I deal
but
with
that's
is
not
nosy.
okay. He needs
to leave because
Yeah.
he's been stalking us.
Oh, so you're worried that he's not supposed to be here right now?
He shouldn't be here.
Oh, okay. So who do you how do you know him?
He used to live 2 doors down.
Oh,
This house right there, but he moved
he
away.
moved out. Well, I'm not here to try to make anything bigger than what it needs to be. Let me get your first name quick.
Valerie.
Can you spell it?
Valerie.
Mm-hmm. Your last name?
Ostrowski.
Okay. Your birthday?
10/16/1981.
81. What's a good phone number for you?
313-407-6132.
6132. Where do you live? What's your address?
Right here.
What is it?
2400 Northwest.
Thank you. All right. Well, we're here because we were informed of some sort of assault that occurred today. I mean, are you saying that there is no assault? This was just a verbal argument?
Yeah, my daughter
or?
and I are just arguing.
Oh, okay. Is it this one?
Mhm.
On the one on the left?
That's my daughter, yeah, right there.
Yeah. Does she live here too?
Yes.
Yeah. Okay. What do we do to come to a solution here? Or is there something else going on, or is it just one of those things where you get a little miscommunication?
It's just it's a miscommunication because we're a divided family. Like her dad and I are going through a divorce.
Oh, okay.
And I just wanted her to take the stuff, some stuff to him, and that's all. It's nothing major.
I see. So he's moved out.
Yeah.
Okay. Were you guys? Everybody was living here, and now he's living somewhere else.
Yeah, he's living with the creepy guy.
Oh.
But he doesn't belong here. I don't know why he's here.
Yeah. So it's the potential is that your ex-husband may have called this complaint in today.
Maybe.
Yeah, and then this is why he's here now.
But that's my husband's not there because my
Right.
husband's not allowed to be here.
Okay. Why not?
Because on October 30th we had a fight and he broke my arm.
Oh wow. Okay. Was he arrested that day or?
No, I was.
Oh, you went to jail that day? Okay.
Well, I went to the hospital actually.
Went to the hospital that day? Okay. So what are you? One of you going through the court still? Is he still trying to pursue charges or?
No, he was never pressing any charges.
He wasn't pressing charges.
No.
Okay, so no one was received a prosecution or a sentence for that
Not
crime.
yet.
No.
I haven't been sentenced yet.
Okay. Is the state picking it up? Do you still have court you're going to? Yeah. Okay. What?
And whatever they did is going to come against me.
I see. So what do we do today? Is there a place where one of you can go, or
We're not. We're fine now.
everybody's
We were
fine now?
just, like,
Okay.
making up in the car.
I gotcha. Okay. All right.
It's just it's so full. She never would sit. It was kind of cold.
Yeah. So there was no assault today. I guess obviously we weren't here, but the only information we have is that there was some sort of assault today. Did things get a little physical just from going back and forth, or a little bit of shoving, or someone's in each other's face,
she was trying
or
to grab keys out of my hand, and that's
she was trying to take the keys for this car?
yeah.
Oh, was it her car?
It's my car.
Oh, okay. She didn't want you to go, or what was it? Why would she want to take your keys?
I don't know. I just didn't want her to leave, I guess.
Oh, so she was trying to take
Well,
the
I
keys.
just wanted to walk away and get some fresh air because
Sure.
that's my mom. And
Yeah.
That's my daughter. And
Does your mom live here?
no.
No.
She was just here.
Oh, okay. So there's some sort of argument about taking things back. Was she taking the keys to go take these things back? Just kind of out of like this was you asked her to go do it and then she didn't want to and then you kind of got into it and she agreed and took the keys, or?
I guess. I don't really know. I
Okay.
told her to take the stuff back and
Uh-huh.
she was packing it up, and then I just decided I don't know. I just decided to take the keys and go for a little drive.
Gotcha.
I didn't really go anywhere.
I see. Okay. Are there other people here today?
No.
No, just three of you? Oh, okay. All right. Well, hopefully if we can get that confirmed, then we can get everybody squared away here. I mean, is there going to be some sort of propensity for violence after we leave? Like, are people
No.
going to have issues after this is all said and done?
No, we're
No?
not having any more issues.
Okay. All right. Well, I guess sit tight for us for a second, and hopefully that we can leave as quick as we just got here. So.
I have a feeling that he called the police
What's
because
his name?
I don't know his last name. His
Uh-huh.
first name is Paul.
His first name's
His
Paul.
last name is like Rodiger. I can't say it.
Okay. But it's possible that your ex-husband sent him over here.
He's trying to force her to
Uh-huh.
go with him over to the other house, to his house
Okay.
where her dad is, but she said she doesn't want to go.
Yeah.
I was
So
like, he can't force you to go.
2124 welfare.
so her dad wants to spend more time with her, and she
No,
doesn't
her
want to
dad
go.
just wants her to come over there for some reason. I don't know.
Oh, okay.
Maybe it's spending time. I don't know.
But I mean, is she older than 18? It looks like
She's 19.
she's 19. Yeah. So she's got the ability to make that decision for herself.
Yeah.
Yeah. Okay.
What's starting this side?
It sounds like we had a disagreement about some packages here. The car's full of some things that have to go back to her father's house. Sounds like they got into a little argument, and then sounds like the daughter here had the keys, and there was a little struggle over the keys, and then she finally got the keys back and came out here and took a drive today. Sounds like we were on the men's when we showed up, that there wasn't going to be any more issues after we leave. The guy down the street might be one of the caller, the guy in the van. I don't know. He might think that's where the ex or her husband or her father lives with this guy. So I don't know why he has to be here today, or if there's something else that we're not aware of at this time. Everybody lives here. It sounds like so.
All right. Can I speak with my partner?
Yeah,
Just for one
give us a
second?
minute, okay?
Rachel, the daughter, said that she slapped her. She's good to go.
Yeah, that's fine. I mean, if was there grandma witness it too, or
Yeah, she said it was on her.
grandma says it's only verbal, so no one saw that one. Okay, all right, yeah, that's fine.
Sorry, I was just calling.
Yeah, no,
Yeah,
it's
we're fine.
understandable. All right, can you step out of the car for me?
You'll have to go to jail today for assault.
Yep.
There's a accusation of assault, so we'll have to run downtown quick. You'll see a judge in the morning and get this squared away, okay? You got some shoes or something with you, or are they in the house?
She
They're-
hurt me.
they're-
How do I get to go?
What do you mean she hurt you?
Because when she was grabbing my
Uh-huh.
keys and stuff,
Oh, that's
she like,
what.
twisted my arm and was holding me.
Yeah, I mean, I can definitely update your statement for that. I
I
mean,
said that we were fighting over keys.
yeah, and I asked if anything was physical, and you didn't say that you were grabbed or arm was twisted or anything.
No, she
It's
grabbed
okay.
the
Yeah.
keys.
Rachel,
I
just step
see.
inside. I'll come back to you in
Yeah,
just a second.
I'll get some shoes or some sandals or something. You guys got some shoes?
Let the record reflect that the recording has stopped at 9 minutes and 59 seconds.
Record may so reflect.
Okay, officer. So if Valerie says that she's acting in self-defense, you wouldn't have any personal knowledge to refute that, would you?
No, sir.
When you began your discussion with Valerie, she did tell you that Rachel tried to grab the keys from her hand, correct?
Yes, sir.
And would you agree with me if I told you that the definition of grab is to grasp or seize suddenly and roughly?
That's what your definition is, yes, sir.
And you'd agree with me that that sounds like an act of aggression?
That's your definition, yes, sir.
And after you spoke with Valerie, you gave Officer McGregor a recap of Valerie's version of events.
Sir?
And you did indicate that there was a struggle over keys, correct?
Yes, sir.
But you did not indicate that Rachel was the aggressor.
No, sir.
You'd agree with me that when investigating a assault and battery, identifying the aggressor is an essential part of the investigation?
Yes, sir.
Isn't it true that Valerie told you that Rachel hurt her that day?
Yes, sir.
And that Rachel was trying to take the keys to the car?
Yes, sir.
And that the car belonged to Valerie?
That's correct.
And there were no pictures taken of any injuries from Valerie?
No, sir. I didn't take any pictures.
And the video was stopped at 9 minutes and 59 seconds. So Valerie was placed under arrest after the officers arrived on the scene for approximately 10 minutes.
Yes, sir.
Prior to Valerie being arrested, Officer McGregor gave you Rachel's version of events?
Yes.
And isn't it true that Officer McGregor never told you that Rachel also said that the parties were fighting over the keys?
That's correct. He didn't mention that to me.
And there was no further investigation regarding the possibility of Rachel being the aggressor in this incident?
No, sir.
Valerie was arrested for assault and battery, correct?
That's correct.
Do you know the statute that you arrested her under? Can you cite that statute?
No, sir.
Your Honor, what I have here is marked as Defense Exhibit I, Proposed Exhibit I. This is a screenshot from the body cam footage that the people have already admitted. I'd like to.
All right, so this is a screenshot from People's Exhibit
People's Exhibit 1.
1. Is that true, Mr. Ring?
I don't have any, Judge, I don't have any reason to believe that it's not.
All right, so without objection, Defense Exhibit I is admitted into evidence.
I was just a little confused about the timing of the body cams.
Officer, I'm handing you what's something. Okay. Hmm? That's been in. Did it end to evidence? Give me 1 second. May I publish to the jury, Your Honor?
You may.
Is that the condition you recall seeing Valerie's arm in at the time of the arrest?
Yes, sir.
Throughout Valerie's testimony, or throughout Valerie's relaying the events to you, she stated, "I don't know," several times to your questions, correct?
Yes, sir.
But you interjected your own theory and words into her mouth on occasions, correct?
No, sir. I'm just simply asking questions for the person to speak about what happened.
When Valerie stated she didn't know, though, you proposed your own theory of what transpired.
I simply ask questions to get them speaking. I mean, I can't go off of my guess and I don't know.
But you do acknowledge that Valerie did say, "I don't know,"
Yes, sir.
several times.
Yes, sir.
And Officer Morick, isn't it true that it was Officer McGregor's decision to arrest Valerie that afternoon?
Yes, sir.
No further questions, Your Honor.
Redirect?
Yes, Your Honor. Did Officer McGregor make that decision alone?
We spoke briefly when we stepped away from Valerie.
Valerie, we just watched that body cam. Valerie told you that she wanted Rachel to take her dad's stuff somewhere.
Yes, sir.
But then she told you that Valerie herself wanted the keys.
Yes, sir.
Did Valerie ever once mention to you that it was self-defense?
No, sir.
We see this picture up here right now. Was there any active bleeding from her arm there?
No, sir, not that I recall.
Did the injury appear fresh to you?
No, sir.
Defense asked you about or grab, if it's aggressive. In your opinion, is the word grab aggressive to you?
In my opinion, no, sir. Not in this type, not in this context.
And you didn't observe any injuries to her wrists?
No, sir.
And once again, in the beginning, she told you that nothing physical happened.
Yes, sir.
No further questions, Your Honor.
May this witness be excused from the people?
Yes, Your Honor.
From the defense.
Yes, Your Honor.
All right, this witness is excused. Thank you for your appearance today. Mr. Ring, you may call your next witness.
We will call Rachel Ostrowski.
All right, Mrs. Strowski, I'll have you come up. Please state your name and spell your last name for the record.
Rachel Ostrowski, OS2RWSKI.
Okay, please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth under penalty of perjury? Okay, please have a seat here and please project for recording purposes. Mr. Ring, when you're ready.
Thank you, Your Honor. Rachel, where do you live?
I live at 2400 Northwest Avenue.
And back on January 2nd of 2023, is that where you lived? Who lived there with you?
At the time, it was me and my mother.
And was anybody else there on that day?
Just my grandmother.
Do you remember what happened on that day?
Yeah, I do.
Can you please tell me what happened on that day?
So my mother had come home from work a bit on the distraught side, and
I'm gonna slowly interject when I hear something, okay? So when you say she was distraught, how do you know that she was distraught?
she just was very down in like the dumps, and I know she was distraught because many days prior, she had also been distraught because of an incident that happened between her.
Okay, go ahead. So after she came home and you saw that she was distraught,
Me, her, and my grandmother all exchanged some words, And then at one point, she got upset and went to her bedroom that her and my dad had used to share, and she started throwing all of his things in the hallway.
Okay, and what kind of, did she say anything before she did this?
She had said she can't help me upset over the fact that I probably didn't want to see her.
And she began throwing items that belonged to your dad out in the hallway, is that what you said? What kind of items were these?
It was a combination of items, clothing, sets that we had given him for Christmas, and a couple model airplanes that he had built.
And you know your dad, would these items be sentimental to him?
Yes, especially the models.
And what did you do in response to that?
I started to pack up all my dad's things in boxes, and I tried to put them all nicely into my car and transport to where he was living at the time. All his things.
And did the defendant tell you to take these items somewhere?
Yeah, she said to get them out of the house.
And she didn't give you any general, she give you any general direction on where to take them besides out of the house? And did you two get into an argument after that?
He did.
Well, so you got into an argument, was it while you were boxing them up or after you had already boxed them up?
A little bit while and after I boxed it.
And do you remember what the argument was about?
Not necessarily, but I do remember what I said to her later on.
And you say you said something to her and she.
I did.
What did you say to her?
What I had told her is, and I was trying to just bring it to realization, you wonder why your son doesn't want to be around you, and it's over situations like this.
And by situation like this, you meant?
The best way to put it is fit she was having over my brother not wanting to see her and just tossing all the stuff into the hallway, going on about.
And what happened once you said that?
Once I said that?
Yeah.
She hit me.
Was this a punch?
It was a slap.
Do you remember what side of your face she slapped you on?
The left.
And was it just once?
It was.
What happened after she slapped you?
After she slapped me, I know there was more exchange of words, and at one point, my grandma tried to say, okay, let's just all calm down. I'm going to leave soon. How about we all go out to eat together before I leave? And my mom didn't want me to leave the house with my car keys and take my dad's stuff out of the house.
And do you know why she didn't want you to do that?
She didn't tell me at all.
And did you, how many sets of keys are there to this car?
There are the main set, which I carry, and then there's the spare.
Where were these keys located when this was?
They were located on a key rack right by the door.
And after she slapped you, did you eventually go to those, did you eventually get those keys?
I attempted to get them back, but
Tell me about what happened when
so when I went to go get them back, my mom had went to her room to prevent me from being able to get them, and they locked the doors to the bedroom, and I should have unlocked it to get them back, but that's not the first time she's tried to prevent me from leaving the house and taking my car keys.
And did you knock on the door to get?
I did knock at first.
And after this all happened, did you send your mom a text?
I did.
We'll back up. We'll back up for a minute. Did you give a statement to the police?
Yes.
Did you call the police?
I did not call the police, but I was informed by.
It's immaterial. It doesn't matter. Who called the police. So when you were being interviewed by the officer, and you told the officer what happened?
Yes.
What did you tell him at first?
At first I told, I tried to tell them what happened exactly, but then my grandmother came outside and interrupted me giving my statement. And then after she interrupted, the police officer was just gonna go away, but then he realized I actually had something to say, so he sent my grandmother away, and I gave the actual statement of what happened.
Thank you. And then so after all of this, you said you sent your mom a text.
Yes.
What did that text say?
Said something about how I love my mom and that I was really sorry and that I should have been arrested too, but there was a reason why I said that part.
And why did you say that?
I said it because I was afraid if she came back, she would do something worse to me.
And have you ever been in a situation involving the police like that before?
Just a general police encounter.
Were you nervous when the police were there?
Yes, because I was nervous after the whole situation.
And is Valerie Ostrowski in this courtroom today?
Yes.
Can you please point to her and describe something she's wearing?
She's attorney and she's wearing black and straight shirt.
Let the record reflect that the victim has identified the defendant.
Any objection?
I don't object.
Okay, without objection, the witness has identified the defendant.
And Rachel, do you want to be here today testifying against your mom? Thank you. No further questions, Your Honor.
Cross-examination,
My witness, Your Honor.
Mr. Nichol.
Thank you. Rachel, good afternoon. We have not met. My name is Mike Nichols,
It's nice to meet you.
and I represent your mom along with Mr. Moss. Okay? I know you testified before, and I know you testified in another court.
Yes.
Remember that a few weeks ago?
Yes.
Okay. Well, I want to just try to put you at ease, okay? I'm going to have some questions for you that may be a little uncomfortable, but I'm not here to beat you up, okay?
Okay.
All right. Deep breath. Okay. Now, if you don't understand a question, will you let me know that?
Yeah.
Okay. Now, the text messages that you sent to your mom were from your cell phone, correct?
Correct.
All right. May I approach the witness stand, please?
You may.
We'll show her what's been marked as proposed exhibits G and H. Okay, Rachel, if you would just look at these first. We had a chance to look at those?
Yes.
All right. And maybe you know, maybe you don't know, but you're in your mom's phone, at least at that time, as Rachel, right? Those obviously came from your phone, true?
Is that a yes,
Oh,
ma'am?
yeah, yes.
Okay, thank
I
you.
forgot.
Don't forget,
Really?
at least a yes or a no, because the court reporter, maybe you will have to make a transcript of this, and the ahas and the ums sound the same.
Yeah, I didn't mean to forget.
It's okay, you're doing fine. You may come take those back from you?
Yeah.
Okay. So these are a fair and accurate representation of the text messages that you sent to your mom?
Correct.
Okay. I'm going to move for admission G and H, please.
Defendants move for admission of exhibits G and H. Any objection?
No objection.
Without objection, defense exhibit G and H are admitted in evidence.
Thank you. You weren't here, but we played some of the video from the officer's body worn cameras, okay? One of the officers had checked his watch to try to use it as a time reference for when the incident occurred. You remember that?
He might have checked his watch. I'm not entirely sure if he did or not.
Okay. Do you remember trying to explain to him that it was somewhere before 3 o'clock that afternoon of January 2nd?
Yes, I remember.
You would have sent these text messages to your mom, and I can show them to you if you want, but the first one was sent at 3:37 p.m. Is that, you want to see it? Here, may I approach again?
Sure.
It's very top one, Rachel.
Yeah. That was the one I had sent right after my mother had been arrested.
That's the point I was trying to make. Can I have that back?
Yeah.
Thank you. Your mom was in jail at that point in time, right? Or at least on our way to jail.
On our way, yes.
And Mr. Ring asked you, you've never been through something like this with the police before. Is that true?
Not this situation, but this is not the first police thing.
Okay, you answered my question. You would not have known how long mom might be with the police in jail, right? And what you said to her at 3:37 p.m. was, Mom, you spelled the M-U-M.
That's how I spell that's how I spell it.
That's what you'd call her.
Mhm.
My 13-year-old calls my wife the same thing, Mom or Mama. Mom, I'm sorry for everything, right?
Yes.
And then you said, I'm sorry I hurt your arm and I fought with you for the keys.
I did.
At 6:48 p.m., you sent your mom another text message, and part of that conversation was, I wish I could give you a hug and apologize. Is that true? You testified here under oath about what you said to your mom that, at least in your belief, I'll use the term precipitated, but led to your mom striking you. Remember that testimony at direct examination?
Yes.
Okay. And you made a statement, something along the order of, what was it again?
I had said, you wonder why your son doesn't want to be around you. It's because of situations like this.
There was a hearing on a personal protection order that you were seeking against your mom a few weeks ago, right?
Yes.
Objection, Judge. I don't know how this is relevant.
Response?
It is prior out of court statement under oath, which makes a substantive testimony. It's used to impeach the witness from her direct examination testimony here today.
Right. Mr. Ring, do you have any copy or transcript of that
I
testimony?
do not, Judge.
All right,
I just asked the witness if she remembers making the statement.
that's fair enough. So the objection's overruled at this point, and we'll allow counsel to rephrase the question.
It looked like you wanted to say something.
I do. I remember that, and I remember the statement I gave, which is, I don't remember what I said. But the next day, I had a conversation with a friend of mine who knew about the event, and I had talked to this person the same day all this happened, and she told me exactly what I had told her I had said. And at that time, this was after the court date.
Sure.
And I didn't remember then, but after she had told me what I had said, I thought back more towards the event, and I realized I did say that.
Not a problem. Listen, you, at the time this happened, you were 19, right?
Yes.
And your parents are going through a divorce, right?
Correct.
And it was kind of a nasty divorce. True? Still is. True? And part of the fight is the custody of your younger brother. Is his name Hayden?
Yes.
He's 14.
Yes, he's almost 50.
When I was your age, my parents went through a nasty divorce too, so I get it, okay? All right. But on March 24th, in that hearing with Judge Garcia, you were under oath, right?
Correct.
Okay, and you're under oath here today. Do you adopt the testimony here today under oath or the prior testimony?
By adopt.
Sure. Which one is the testimony that you're gonna stand by?
The one I'm gonna stand by is the one I gave today, because as I had said, after thinking about it, and back to the day, that is what I said.
You told your version of events with Mr. Ring under oath on direct examination. Remember that? Okay. Tell us again what happened.
What happened was my mother had come home distraught. And the reason why she had been distraught is because of the whole situation with my brother not wanting to see her ever again. see her in general. And then there was more exchange of words between me, my mom, my grandma, and then my mom went off to her room and started throwing things into the hallway that belonged to my father.
The things belong to your father.
Yes,
The hallway was in the house that your mom and you were living in at that time.
yes.
Now, would you agree that on the day that this happened, I'm going to use the term frail. You know what that means? How about this? Poor health. You know what that means?
Yeah.
Your mom is not in the best of health at this time. Right?
Last I checked, her health wasn't the greatest.
And if you don't remember or don't know, just say that, okay? Your mom has gone through 3 strokes
Throughout her life, yes.
and has lupus and asthma. Got just a few more things for you about the details. Okay. And I'm, I know that this is not easy. I know you don't want to be here, but I have a job to do. I have a duty to your mom. Okay.
Well, I understand.
Okay. Thank you. Do you remember, and I'm going to hold my 2 hands together, getting your nose and your mom's nose, you got within about 6 inches of your mom's nose?
Oh, I don't remember being that close.
Did you get close to her?
I mean, I was standing in front of her, but I wasn't like really close as you're putting it. I stayed near where she was.
Do you remember getting kind of, I'll use the term, in her face?
No, I didn't get in her face.
And your testimony is you didn't say anything other than you wonder, what were the words again?
You wonder why your son doesn't want to be around you. It's because situations like this.
Situations like this means she was in a bad mood? Or, no, I'm sorry, your term was distraught. Distraught.
Distraught, but that's the incident where she was throwing things was not the first one that had happened. That's happened on many occasions, and I was just trying to bring it to her attention. Situations as that was happening currently with her throwing things and being upset is one reason why my brother doesn't want to see her.
And do you recall that?
Your Honor, at this time, there are potential witnesses.
He's got a sequestered witness.
All right, so any witnesses that are potential witnesses in this case have to leave the courtroom. So we don't want one witness seeing another witness's testimony. All right, you may proceed.
Just one of those rules of the road, as they say. Is it your testimony that, at least your perception is, your mom hauled off and slapped you because you made the statement to her, you wonder why your son doesn't want to be around you? Sure. What I took away from the direct examination, Rachel, was mom, they've been calling her defendant, but mom, Val, right? This person right here.
Yes.
Who, you've known for 20 years?
Yes.
Okay. Hauled off and slapped you right after you said, whatever it was that you said about Hayden not wanting to be with her.
Yes.
Was that instant?
Right after I said it, she did slap me.
Your belief is that is what set off the match. Was there a time, a year before this, that your family had a meeting with your mom? Or tried to have a meeting with your mom?
Objection, Your Honor. This is going into evidence that we ruled on this morning, Your Honor.
Well, this sounds like we're getting into a specific act territory. So let's have counsel approach. Okay. So I've had the opportunity to speak to counsel at the bench. The objection's overruled at this point, and in that framework that counsel indicated, you may continue.
The family wanted to have a meeting with mom about a year before this incident that we're here in court on.
Correct.
And I call that, from what it's been described to me, kind of like an intervention.
Yeah, I know. In a way it was, because we were all concerned about her.
She'd been kind of, and you all have talked as a family, but she'd been kind of sad for a while.
Sad more on the depressed side.
And I need to cover that second piece of this that you testified to on direct examination. Okay, so after the slap, your testimony is mom goes to a bedroom.
Her bedroom / her and my dad's.
I know it's really hard to not describe it as this is my parents' bedroom and this is mom and dad's bedroom. It took me years before I changed it from the couple to the single. The room that your mom slept is where she went. And your mom, did she lock the door?
She did.
You testified that you knocked on the door.
I did not.
This exchange, I'm going to say part 2, okay, of the physical stuff. Are we on the same page?
Yes.
Okay. This part of the exchange took a little bit longer, right?
I would say I did.
You go to the door and you're pounding on the door,
I know.
and mom's got the keys that you want. And the keys are to the car that is mom's car, right?
The car belongs to both my mom and my dad.
Okay. So your parents' car.
Yes.
And you are not necessarily someone who has unfettered access to this car without getting permission first, right? Like you gotta sit, you can't just go use the car anytime you want to.
No, they allowed me to use the car anytime, to go to school, to go to work.
Keys were mom's keys.
They were my side keys, and she took the spares.
You wanted them, right?
Yes.
You wanted them from your mom.
Yeah.
And your voices are gonna be raised.
Our voices.
Yes. She's on the other side of the door, right? And the door's locked. You want those keys that are on the other side of the locked door. Okay. Your testimony is voices are not getting raised. They're just normal tone, just like I am right now.
They're slightly raised, but not yelling, or screaming, just mid raised.
Invariably, when we saw prosecutors exhibit 1 and I think our exhibit M, we saw parts of the body worn cameras when the cops, he's going to use cops, the LPD officers, when the cops arrive, mom's in the car, your mom and dad's car. You're standing next to the car.
I was inside the car with her, but then I got out of the car.
How is it that the two of you end up from she's on the other side of the locked door to you guys are in the car? Take us through that.
So after I tried to get the keys back to my mom, the keys ended up breaking, and my grandmother had said something along the lines, if things don't stop, I'm gonna call the police myself. My mom had said whatever, she left the house with both sets of keys still. And
Can I stop you right there?
yeah.
So it's clear for the jury, mom leaves the house and goes to the car first?
Correct.
Okay, go ahead, continue.
she leaves, and then comes back shortly after she leaves. And I do go outside to apologize a bunch of times because I live with her and I didn't know if I didn't say I was sorry for everything, if she was gonna do something worse.
The police arrive and ask questions, two officers, right? They ask questions of you, right? They ask questions of grandma. They ask questions of mom, right? They arrived after the second part of the physical stuff, right? There was a point in time before the cops, the way they phrase it is clear the scene. They were still on the property, right? There was a point in time that you said, am I going to jail too? Right?
I didn't say that.
Okay. Rachel, I don't believe I have anything further. I'm sorry what you're going through, okay? Good to meet you.
Redirect, Mr. Ring.
Thank you, Your Honor. Why did you ask if you were going to jail too?
The reason why I asked if I was going to jail too is because I didn't know what my mom really had said. And I didn't know if they needed to bring me in for any further questioning because there were two other times the police came, but it wasn't really for an arrest. Well, there was one other one for an arrest, but more or less, I didn't know if I needed to be questioned more.
You sent those texts and you sent them right after the event happened. And why did you send those again?
I did it because I felt like if I didn't say I was sorry, then that, because I also said I should have been arrested too. I said that because I didn't know whether or not what if she came back, what she would do.
You were afraid.
I was.
And you said it took you a little while to remember exactly what you said to her to make her slap you.
Correct. A lot of things have been going on between all of this and my job in school.
And reaction was just instant once you said it. Is that what you said? Is that correct?
Correct.
And after that happened, what did you think right after that happened? Do you remember what you were thinking right after you said it and then you got slapped?
I don't remember what I was thinking. Solely because of the fact that that's not the first time she's done something like that.
And with regards to the car, is that your daily driver?
Yes,
Does your mom have a separate vehicle that she drives?
she did.
Was that in the parking? Is it a parking? Do you have a parking lot or is it a driveway or garage?
We have a driveway and a garage, but right now the garage has a bunch of stuff in it. You can't get
Was that separate vehicle that your mom usually drives there that day?
Yes.
So she had no reason to take the keys away from you?
No.
Thank you, Judge. No further questions.
May this witness be excused from the people?
Yes, Your Honor.
From the defense?
Yes.
Okay. You may be excused. Thank you for your appearance today. Mr. Ring, your next witness, please.
Your Honor, at this time, the people would rest.
We will take a 5-minute recess to allow some time and then continue with the defense case. But we'll take about 5 minutes just to just as a break, just before we get going again. So let's do that. We'll all rise to the jury, and you can thank the jury for. We'll make sure that door is shut. All right, you may be seated. And so we're still on the record. Are there any, so do the people rest, and you've rested? Are there any motions to come to the court's attention before the defense starts their case?
None on behalf of people. Thank you, Your Honor.
Any from the defense?
Your Honor, this is just not a summary verdict motion kind of case.
Okay.
We're not gonna make it.
All right.
If I get grief for it, I get grief for it.
Right, well, you won't get grieved by me. But, all right, so with that understanding, I'll allow counsel to at least relax for about 5 minutes, and we'll start the defense case, okay? All right, thank you.
You did.
All rise.
Yeah.
It's a
You have pled not guilty to the charge of assault of your daughter. Why?
Because it was out of self-defense.
At the time that this happened, January 2nd,
We're gonna address that issue. Getting a little loud. You may proceed, Mr. Nichols.
on January 2nd of this year, were you living at 2400 Northwest Avenue in Lansing, Michigan?
Yes,
And where do you live now?
in a shelter.
You employed?
Yes,
On the day that this happened, we heard testimony about you going to work. Where were you working on the day that this happened?
at the time I was working for Waverly Student Center, it's childcare.
Do you still work there?
Objection, Your Honor, relevance.
Response?
It's just a foundational question so the jury can understand this person.
I'll allow it. Objection's overruled.
Where are you working now?
I do not work there anymore. I had 2 jobs at the school. Well, there are 2 different schools. I still work as a lunch and food service. I used to be a lunch aide and I work the high school.
On the day that this happened, did you work
Yes, I did.
at Waverly Schools?
Yes, I worked at the student center in that morning.
Now, this was January 2nd, and if I recall, that was a Monday. True?
I don't know the day, but it was over Christmas break.
Call about what time you came home?
I got off work at 12:30. I had to a couple errands and I got home at 1:30, around 1:30.
We heard Rachel testify about who was living there, but is that true that Rachel and you were living there?
Yes,
At the time she was 19?
yes,
Was your mom there?
yes.
Anybody else there?
No, just the 3 of us.
When you got home from work, was there a plan to do something together?
I don't know. I got home and they asked me if I wanted to go out to eat, but I didn't. I just wanted to be left alone.
Rachel had testified about you being down. Is that correct?
Yes, the whole weekend I was just a little sad.
So there was plan, or they talked to you about going out to eat. You don't want to go out to eat. Take us through what happened and the point at which we get to the slap, then just stop there.
Okay. So when I came home, they asked me if I wanted to go out to lunch. I said no, I just needed to be left alone. It was a long, trying weekend because of my son. I don't really know why he doesn't want to see me or if he really even doesn't want to see me, but that's just what I've been told.
You're sad about that.
So I was sad the whole weekend. I cried the whole weekend over it.
Now, as you're expressing this to your mom and your daughter, do voices start to get raised, or you got to give the jury a window into the world at that point?
Yeah, because I was crying and I said, please leave me alone. I went in my room, I laid on my bed. And then they both came in there. They're like, stop acting like a baby.
Without saying what other people said, okay? Certain rules that we have to follow, okay? So there's discussion about why you don't want to go out to lunch and they're trying to get you to go out to lunch. Is that a fair characterization?
Yes, that's correct.
All right, okay. How long does this go on until we get to the point where the slap occurs, if you can recall?
I don't know how long it was. It felt like forever.
Take us to the point at which you strike your daughter. What happened?
She just, she walked out of the room and then in the hallway, she was still
She was saying things?
saying things to me.
Were they hurtful?
She called me a baby. She told me to grow up, and
Did she come back into your bedroom?
later, not right away.
Okay. And later, when she came back in the bedroom, is that where the physical stuff happened?
Yeah, that's when the physical part happened.
Now, were you acting in self-defense?
Yes.
Why?
I decided, because I was sad, maybe to make me feel better, to ask, to pack up some of his things, just so I didn't have to look at them anymore. And I did. I threw some of his clothes and stuff, magazines that were on his dresser out into the hallway and asked her to help me start packing them up. That,
Now, okay, when you did that and said that to Rachel, did her emotions start to escalate? You understand what I'm saying? We're asking?
yes.
Okay. What did you observe from her? Okay. Without saying what she said, but your physical observations of her causes you to give that opinion.
She was, not sure how to word it. She was getting angry at me for wanting her dad's things to go away. So then she was swearing at me. And she called me a fucking bitch because I wanted her to take her dad's things out of my room.
Did there come a point in time that she got, may I approach the witness?
You may.
Oh, you got.
I got some.
Did there come a point in time that she got into your personal space?
Yeah. We were in the living room.
You were in the living room?
Yeah, because when I asked her to pack up some stuff, I took some, before I started throwing them out. So
All right. So this goes from bedroom to living room, right?
because I left the bedroom because I wanted her to pack up his things.
And she followed you?
She was already out of there. Because that's where she was. I just tossed the things into the hallway. She was in the living room. And I just asked her, like, can you please pack up his things? I can't look at them anymore. We've been going through this divorce for 2 years.
Now, you gave some testimony a few minutes ago that you observed her to get angry when you started the discussion about packing up dad's things. Your husband's name is Chris?
Yes.
Okay. You have to describe that. Give us the picture of why you think, why your interpretation is to say that she got angry at that.
Just the look on her face. And like I said, and she called me a fucking bitch. And then she got like in my face. And she's done that before.
Stop. Hold on a second. Deep breath. Can you show the jury, maybe use your left hand and right hand, how close she got to your face?
She was like right here.
For the record, you've got your right hand, and I would say, was that 8 inches, Ms. Ostrowski?
I don't know. It felt like she was this close.
You said she felt like she was this
She
close.
felt like she was this close, but she was like right here.
Okay. You moved your right hand to about a couple inches from your nose. It felt like it was 2 inches, but you think it was more like 8. Fair?
Yes.
Okay. And at that moment, did you honestly and reasonably believe that you had to use force to protect yourself?
Yes, like I said, she's done it before. She's put her hands on me and
Okay, so what did you do?
because she was so close, I just swatted at her. I didn't mean to hit her. That part was an accident. And I said I was sorry. And then she gave me that look like she was gonna kill me.
There's a term that we use, it's called imminent, or it's gonna happen instantaneously, right now. Did you instantaneously, let me rephrase that, did you think that you were about to instantaneously be touched by her?
Yes.
And did you use any other force other than this, as you described it, a SWAT to protect yourself?
No.
I know you may not have been thinking clearly, but did you think that that was appropriate to do in that moment?
I don't know. I just wanted her to get out of my face and away from me. Because it's not the first time she's done things like that before.
Was it, would you describe yourself as excited?
I don't know what you mean by that.
Well, things were happening fast.
Yeah. I guess they would be happening fast.
Were you trying to process all of that information instantly?
Yeah.
Could you tell whether your heart rate was going up?
Oh yeah, I couldn't even breathe. My heart was beating so fast.
Now, Rachel testified to sort of two sections or two parts of when stuff got physical. What happened after the SWAT?
She's grabbed me before. I didn't know what she was going to do. I needed to get away. And so I ran into my room because it was the only place that I felt where I could maybe get away from her. Because if I had ran outside, she would have chased me down. She's done that before and grabbed me. And
Now, we've heard testimony about keys. Did you have keys?
I did. I had my key. I had my keys and her keys. Well, they're all my keys.
Keys to what?
My car.
And I think there was some testimony from Rachel on redirect about whether this was her, the term, was it daily driver? Daily,
That would be the term. I guess.
daily driver. Was that car Rachel's daily driver?
She drove it a lot, but she still has to have, it's still my car and she still has to ask to drive it. I mean, if she wants a car, she can buy her own, but she'd rather just use mine, I guess.
So why did you take both sets of keys to the bedroom?
I don't know. I mean, I don't really know.
Okay, let's go with this. What happened when you went in the bedroom? Did you lock the door?
Yes, when I grabbed my keys, I ran down the hallway. I went into my bedroom. I locked the door. I sat on the floor behind the door with my back up against the door and my feet up against the dresser to try to keep her out. Like I said, she has physically hurt me before.
No.
I didn't know.
Now, at this moment, would you describe this part of the physical stuff as louder than the SWAT? Not as loud or the same?
Louder.
And how long does this part last where she's at the door?
It felt like an eternity, but it didn't take her more than probably less than a minute to actually gain entry into my room.
So she comes through the locked door.
Yeah, she entered the locked door.
And we saw on the video, prosecutors 1 and RM, when the police arrived, the two of you were at the car, right?
Yes.
Okay. And is this the car that we've been talking about?
Yes.
The car that belonged to the sets of keys that you had?
Yes.
And how did you get from the bedroom to the car?
After I got up off the floor, I went outside. I ran down the hallway. I went out the door. I didn't know what was gonna happen. I didn't leave with anything. I had no coat, no wallet, no shoes. I just needed to get out of there because she broke into my room.
Did you go right to the car?
Yes, I went to the car and then I left.
Was the car locked or unlocked?
It was locked.
Okay. So did you have a set of keys to unlock it?
I do, but my key doesn't I don't have a fob for the car because there's only one. The other one broke. So she had the good keys with the fob, so I had to like unlock the door, frantically unlock the door with the key and the horn honking like crazy because that's what it does if you don't disarm it. And then I left, and she literally came running out of the house as soon as she heard the car honking. So I drove away.
Drove away, did you go back?
I'm sorry, what's that?
You obviously drove back.
Yeah, 'cause I couldn't go anywhere. It didn't have a wallet. I didn't have shoes.
All right. How long does that part take?
I drove around my neighborhood, and then I sat at the church at the corner for a little while. I was gone half hour, maybe 45 minutes. Long enough for her to calm down and to diffuse the situation.
So you come back, you pull in the driveway. Did you get out of the car? Did you stay in the car? What happened?
I stayed in the car. As soon as I pulled up in front of the house or into the driveway, she came running out the door.
Things
And
calmed down? Had things calmed down?
I think so, because she got in the car with me and she tried to sit on my lap, but there wasn't a lot of room. So, but she was hugging me and she kissed me and she told me how much she loved me. And she apologized for hurting me. She said it should have never happened and she felt really bad.
How long after that, when she comes to the car and tries to sit on the lap? How
That was
long?
like right after I got back. So I don't know if she was looking out the window or what, not, but it was like immediately.
How long before the police arrived?
Didn't feel like it was very long. Almost like they were like, somebody was waiting for me to get back. For them to show up. It was really weird.
We see and hear your interview with Officer, I think it's Murlock, it's the second police officer testified.
Yes.
And initially you tell him, hey, nothing happened, right? You agree with that?
Yes.
Why did you tell him that? Why didn't you just tell him, hey, she got my face and I had to swat her away?
Because she's my daughter and I love her. I didn't want to get her in trouble.
At that moment, did you know whether she was there? I'm sorry, let me rephrase that. At that moment that Officer Murlock's talking to you, did you know whether they were there over the SWAT, the first thing, or the breaking down of the bedroom door, the second thing?
I didn't know why they were there. They didn't tell me.
Well, they told you they were there.
Well,
first,
yeah.
But you just didn't know which one.
I didn't know.
And so we're clear, what you did in terms of the physical stuff was you swatted her?
I just wanted her out of my face.
And is that what you deem to be necessary in this situation?
Yes.
Nothing further.
Thank you. Cross-examination from the people.
Strowski,
Yes.
you initially told the officers that nothing physical happened, right?
I didn't use those words, but no, I didn't tell them that she assaulted or that she hurt me because I didn't want to get her in trouble.
You told them it was just a verbal argument, right? A verbal disagreement. Were those the words you used?
I don't remember what I said.
And you didn't mention to those officers about anything being physical until after they had told you what Rachel said, right?
I don't remember. I just didn't.
If you don't remember, that's fine. You didn't tell the officers about any injury you might have had until after Rachel had already told the officers and they told you what she said, right?
I don't remember when I told them. I just remember I told them.
And you never told officers about her knocking on your door, did you?
No, again, I don't.
You
I didn't
never,
want to get in
just a yes or no is fine.
trouble.
And you never told officers that she followed you to your room, did you? You never told officers any of this until after you were told what she said, right?
They didn't tell me what she said.
Until after they told you that they were taking you for an assault.
No.
And so those officers wouldn't have any reason to open your door, would they?
No.
You didn't tell the officers the whole story that day, did you?
No, not at first.
So let's go back to when you were throwing your husband's stuff in the hallway. And you said Rachel was in a different room, right?
She was in the living room.
And she was yelling at you.
From the living room, yes.
And you said she seemed angry.
When I told her to pack up his things, she was mad, yes.
And she was cussing at you.
What she always does.
And by your words, calling you a fucking bitch.
That's her.
And then you approached her. You were so
No.
scared of her, you walked into the living room where she was, right?
No.
So what did you do then? That's what you testified to, that you walked into the living room.
I did. I walked into the living room.
Thank you.
But that was before.
You were really upset about the things your son had said, or you had heard the things your son had said.
I was sad. I was not mad.
So Rachel's comment to you really hurt, didn't it?
No.
Oh, you were fine.
I was not mad at her.
You have another car, right?
I do not.
Oh, you don't? You didn't at the time?
My dad's truck was there, but I no longer have that.
And you said Rachel was in your face,
At the time.
and you said you just wanted you were going to your room to diffuse the situation because you wanted to be alone. But you took the keys with you, so she couldn't leave.
Because it's my car.
But you were scared of her. But you wanted to keep her in the house where you were.
She could have left.
That's a yes or no.
No,
No, you weren't scared of her.
no, I'm scared of her, but no, I did not take the keys so that she couldn't leave.
And you called Rachel violent, right?
Yes,
Said she'd been violent in the past, right?
yes,
Isn't it true? You've been convicted of domestic violence against your husband, Chris? That's a yes or no.
yes.
She said that mean, hateful, and nasty thing to you. So you slapped her in the face, didn't you?
No,
No
it
further
was
questions, Your Honor.
Redirect.
Well, let's start with the rest of the story. The prosecutor cut you off just now when you were trying to explain that last question. Tell us why you slapped her. Or, I'm sorry, your word was swat. Swat.
Out of self-defense. She's attacked me.
Let's do this. Prosecutor just opened up the door and said you've been convicted of domestic violence with your husband, Chris. Right?
Yes.
What's your side of the story?
Your Honor, that's not relevant to this matter.
So what's the objection is relevance?
It would be, Your Honor, and it would be, Your Honor, and we could call in more witnesses. We don't need to relitigate this, Your Honor. It's already been litigated in the past.
So I think this would be argued out of the presence of the jury. So I'm going to have the court officer take the jury out and we'll put this argument on the record, okay? But I don't know what they're gonna argue, but I haven't determined that it should be listened to yet. So I'll rise for the jury. All right, we can shut the door. So the objection is to relevance in regards to the vetting of the witness under similar other acts motion. The ruling of the court was that if there was testimony concerning the victim as the initial aggressor, that could go to reputation and opinion, which the witnesses testified to. They can be cross-examined on specific acts, which is what my understanding is you're doing.
That's correct.
So on redirect, now the question is, can we get into the nature of the specific act? And that's the objection. Is that correct? All right. Response.
This absolutely has the right to present a defense. Now they're trying to convict her on her propensity, not on her acts, alleged acts here today. She gets to defend herself.
The ruling, first of all, character was opened by the defense. It was not opened by the prosecutor. So the initial aggressor and the character of the witness under the character rules was opened by the defense. And it can be done as to reputation and opinion, which means that the witness can be vetted on specific acts. Now on redirect, you're getting into the nature of that specific act. And I think that's out of bounds.
Except he didn't ask about reputation and opinion. He said, isn't it true that
you said your mother was violent? That was a question.
No, his question to her was, isn't it true you were convicted?
No, but before that, that preceded that question was my understanding was You say your mother's violent, and she said, yes. Yeah, your daughter's violent. That was my understanding.
The problem with the whole thing is Val with Chris has nothing to do with Val with daughter Rachel. And that's where this whole thing falls.
No, I disagree. I disagree with that. I think this witness indicated the victim was the initial aggressor, indicated that the victim was violent, and therefore, and that she was scared for her life. And therefore, the prosecutor can question and cross-examine on specific acts, but that doesn't mean on redirect, you get into the nature of the specific act. That's where we start relitigating a prior character problem, and I disagree with that.
I know, and I know the court doesn't mean to do it, but the
All right, you may be seated. We're back on the record, docket 23-00011. We came after a recess. The attorneys have argued. The objection sustained at this point, and Mr. Nichols, you may proceed.
The prosecutor asked you on cross-examination about why you walked back into the living room, and to direct your attention to those questions and answers, okay? Remember that? He said you were so scared of her, you still walked back in the living room. And you gave an answer and he cut you off. I want to let you finish that answer. Why did you walk into the living room? Do you understand the point of the chronology that we're at? Okay. So on cross-examination, say at least yes.
Yes.
Okay. On cross-examination, he said you were so afraid of your daughter, you still walked back into the living room. Remember that question?
Yes.
Okay. And you said yes, and you looked like you wanted to try to say something more, but he cut you off. So what is it that you wanted to say?
I don't remember.
Okay. Been there, done that. The point where you had been testifying about you were upset about his stuff, threw his stuff, you told her to take the stuff to him. You're in the bedroom, right?
Yeah.
And then you walked into the living room, which is where the SWAT happened, right? Is that correct?
Yeah.
Okay. Why did you walk into the living room?
That's when I went, that I only went in the living room the one time. I went into the living room to ask her to pack up the stuff. I never went back into the living room. I went into the living room. I was in my room. And then I asked her to pack up his stuff. I went into the living room, asked him to pack up her stuff. Asked her to pack up his stuff. And that's when she was swearing at me and got in my face.
That's where she got within what seemed like 2, but was actually maybe 8 inches.
Yeah.
All right. And then at the beginning of cross-examination, the prosecutor spent a lot of time asking you about what you didn't say to the LPD officers. Okay? Direct your attention to those questions and answers. Right?
Yes.
And he said, you didn't tell him the whole story. You conceded that you did not, right?
Yes.
Why didn't you not tell them the whole story?
Again, she is my daughter. I love her. I did not want to tell them that she grabbed me and she gained the keys from me by grabbing onto me and hurting me. Like she knew I was recovering from my injury. She didn't care. All she wanted was the keys.
And she got the keys?
All she ever wants. What she wants, she gets. That's just how she is.
Objection, not responsive.
Response?
I don't think it was non-responsive. I think it's fine.
Just answer the question asked, ma'am, okay? The objection's overruled.
Can you ask the question again?
We covered it. The last question was, she did get the keys then.
Yes, she got the keys because she got into my room. The door doesn't, you don't need a key to unlock the door. You can use change, you can use a paper clip, it doesn't matter. She knows that. She couldn't get all the way in the room, but she got in enough to get what she wanted. She wanted my keys. And she wanted to make sure that I knew that. She could get what she wanted it.
I believe I have anything further.
Thank you. May this witness be excused from the defense witness?
Yes.
May the witness be excused from the people?
Yes, Your Honor.
Ma'am, yeah, I thank you for your appearance today, and you're free to go back to your seat. The witness is excused. Defense, you may call your next witness.
The defense rests.
Is there any rebuttal from the prosecutor today?
Can I have one moment, Your Honor?
You may.
No, Your Honor, thank you.
All right. So the proofs in this case are over, and what we're gonna do now is we're gonna prepare for you a set of jury instructions, all right? So that you'll have them with you. It should be pretty straightforward, okay? Concerning, we have jury instructions already made. I want to make sure both counsels see it before I read them to you. Then we'll do closing arguments, and then we'll let you deliberate on the case. Before that, we get to remove one of you. That's either good or bad. I don't, either buy a lottery ticket or don't buy a lottery ticket. I don't know. But at this point in time, we're going to be in recess for about 10-15 minutes, and then we'll get back on the record. Okay. So you can go with the court officer. Seated. Now I'm second guessing our process as it gets later in the day. So let's go ahead now that I've kind of processed this. We're back on the record 23-00011. What we're gonna do is we'll do closing arguments first. We'll do the people's closing argument. We'll do the defense closing argument. We'll do the rebuttal. And then I'll read the instructions. And then we're gonna pick one of you off. And then you'll go and deliberate, okay? So that's the process that I think that's the process as it gets past 5. So Mr. Ring, you may proceed with your closing argument.
Thank you, Judge. 1 second. Thank you for sitting here today. Thank you for listening to both sides. Thank you for keeping an open mind throughout this trial. The defendant was disrespected. Mean things were said. Nasty things were said. So she slapped her daughter. Ladies and gentlemen, that's what happened here. That's an assault, and that's what happened. Rachel got up on the stand today, and she told you what happened. You heard it from her that her mom got into an argument. She came up here and she told you what she said. She wasn't proud of it, but she told you anyways because she thought you all needed to hear it. She couldn't remember it from the first time, but thinking about things, we tend to remember things the more we think about them. So she remembered what she said, and she told you what she said. You heard from the officers involved. They were there after the fact. They only have the 2 sides of the story to go off of. When the officers first approached the defendant, nothing happened. It wasn't physical. It was just a verbal argument. They first approached Rachel. She kind of said the same thing. She said, we were just in an argument. She had somebody standing over her shoulder, watching her, making sure she wasn't going to say anything. Only then, when the grandmother was removed from the situation, Rachel broke down and she said what happened. She didn't feel comfortable telling the officers what happened when everybody was out there. She told the officers that her and her mom exchanged words and that she was slapped in the face. It's the same story, same thing she got up and testified to today. It's the same thing she told you. She didn't back down. She didn't shy away from the nasty thing that she said to her mom. She told you what it was. And quite frankly, it was probably meant to hurt her mom. She was a little upset that her dad's stuff was getting thrown out. We heard about that. We heard from the officers that the defendant didn't tell them anything happened until after Rachel had already given her side. And then she wanted to cover what she had done. So she tells them, well, I was hurt too. No injury on either party. The officers didn't observe. She doesn't tell the officers anything about a door being involved. Defense wanted to question the officers about why they didn't do this, why they didn't do that. Quite frankly, it's because they didn't know. Nobody was there to tell them that. They asked the questions. And defense wants to say that one of the officers was basically coaching the defendant on what to say or putting the words in the defendant's mouth. She wasn't giving him anything, so he was just trying to ask a follow-up question to get more information about what happened. And the only reason they didn't have more information about what happened is because she refused to tell them. And the only thing she did tell them was nothing happened in the beginning. I read to you the elements of assault and battery earlier. And what I have to prove to you is the defendant either attempted to commit a battery or did an act that would cause a reasonable person to fear or apprehend an immediate battery.
A battery which is a forceful, violent, or offensive touching of a person or something closely connected with that person. Second, the defendant either intended to commit that battery or to make that person reasonably fear that that battery happened. A battery happened, and she intended it. She was disrespected, and she was slapped in the face for it. Ladies and gentlemen, I would ask that you come back with a verdict of guilty. Thank you.
Closing argument defense. Mr. Nichols.
She acted in self-defense. She acted reasonably. She was justified. The prosecutor has to prove beyond a reasonable doubt with his testimony and his evidence, not his questions of Ms. Ostrowski or any other witnesses. Not with the arguments, but with the evidence that came from this witness stand. He had a video of the out-of-court conversations. They've got the burden. They've got the burden to prove. Judge Flores is going to give you this instruction. They have the burden to prove essentially that she was not justified. I know it's kind of awkward. We went through that this morning, trying to disprove the negative, but they've got to disprove beyond a reasonable doubt that Val did not use only that which was reasonable to avoid the imminent harm or the threat of imminent. And you will get this instruction. It's 7.22, use of non-deadly force in self-defense or defense of others. Didn't hear it this morning because the evidence had not come in yet. Right, no, but you'll hear it now. Part of the instruction is not just that a person has the right to use force to defend herself under certain circumstances, but if you find that a person has acted in lawful self-defense, her actions are justified. And that's why I used that term this morning. Was she justified? And she is not guilty of the charge of assault and battery. And the way I like to look at it is this. If you don't walk back there and the six of you who decide unanimously agree, okay, should she be convicted of this? If that's not an easy yes, then that's reasonable doubt. And that is a verdict of not guilty. The judge will also instruct you that when Val Ostrowski acted, they call her the defendant because that's just the way the rules and instructions are set up. She's a person. Her name is Valerie Ostrowski. If she acted honestly and reasonably to use the force to protect herself from the imminent, or in other words, going to happen that instant, unlawful use of force by another, and if her belief was honest and reasonable, even if it turns out later that she was wrong, that's still lawful self-defense. And it's not just tipping the scales. Does Valerie tip the scales versus Rachel? Was Rachel so much better as a witness for the prosecution than Valerie that it convinces you beyond a reasonable doubt? The way I like to look at it is, that old saying about when you're in the woods and you see a bear, you don't have to outrun the bear, you have to outrun the other guy. It's kind of like that. It seems kind of trite, but it's our system. They've got the burden, as it should be. It's that way in every single courtroom in the United States of America. And for good reason, because in my opinion, the hardest thing a government should do is convict one of its citizens of a crime. Now, this is an important piece. The person is justified only if they use that degree of force that seems necessary at the time to protect herself. She must have used the kind of force that was appropriate to the attack made and the circumstances as she saw them. When you decide whether that force was necessary, consider whether she knew about any other ways of protecting herself. But you may also consider how the excitement of the moment affected the choice that the defendant, Valerie Ostrowski, made. Now, when you talk about the circumstances, there is another instruction that you will get. And that is what Val knew about the prior act of which that she had previously attacked, is essentially what it is. Was there prior conduct by Rachel against Valerie that is part of the circumstances in Valerie's head? And I think we heard that testimony from Valerie on the witness stand. She did it before, she grabbed me before. And that makes her justified. And then in claiming self-defense, Val must not have acted wrongfully to bring any assault. And in my humble opinion, and again, what I'm telling you is not evidence, just like what Mr. Ring tells you is not evidence. This is just argument. In my humble opinion, this is one of those cases that checks all the boxes. Certainly, when it comes to the burden that they have to get over the burden of proof, which is beyond a reasonable doubt, the highest form of proof in the American justice system. This is a not guilty. In my opinion, this case should not have been charged. Let's just make a quick point about the police officers. You heard the testimony from two of them. They weren't there. They didn't see it. They respond to calls like cops have to do. They get their list of calls in their queue. They got to go to them and deal with them and take care of them. The guy who made the decision was the guy who'd been a cop for not quite a year. In January, definitely not. And you all can go back there and reflect upon how Officer McGregor and Officer Murlock testified. Officer Murlock, when he was asked by Mr. Ring, I thought it was instructive. Well, did he make it alone? We had a brief conversation, and you can see it. That's one of the reasons why we wanted you to see his body worn camera. So you can see McGregor kind of made up his mind after he went and talked to Rachel. And it was not even 10 minutes that they made a life-changing decision. Now, their burden out there in the field is simply probable cause, enough to make an arrest. That's fine. That's way down here. That burden of proof is way down here. The burden for you as jurors is way up here. You've got to get over the burden of proof beyond a reasonable doubt. I submit to you that the prosecutor did not do that in this case with testimony. Now, as I reflect on this case and what we heard today, a lot of things have been going through my mind, and I've looked at body worn camera video, read police reports, listened to witness statements. And it's unfortunate that we're here and everything that's going on, the backdrop of all this. The divorce is part of the background, but that's not part of your analysis when you go back there to decide whether or not every element is proven and proven beyond a reasonable doubt. Shouldn't decide, hey, feel bad for Rachel. I feel bad for Rachel. I think you heard me talk. I went through my parents getting divorced when I was at that age, and it was ugly. Feel bad for Valerie? It's not bad either, right? And I think there's even an instruction on that from Judge Flores. Sympathy for the person charged is not part of it. It's perhaps what was in Valerie's mind is part of the circumstances. But what goes on from here in the family dynamics is not part of what we want to consider. So I'm just going to say that right now. We've had a long day. We've all paid a lot of attention. And I tried to represent to you that I would just get to the point. I may have talked a little bit longer than Mr. Ring on my closing argument, but let me make a point about that. Mr. Ring is the prosecutor with the burden of proof. He gets to go first and he gets to go last because he's got the proof. So we'll hold it against Val if I talk a little bit more than you would have liked. Okay. I just think Val needs someone to fight for it. So You go back in the jury room. Here's how I would ask you to consider the presumption. The presumption is innocence, right? What we start with, we all covered that this morning. Really, it's the presumption of not guilty. When you get the verdict form from Judge Flores, it's going to say not guilty. So the presumption is not. Just benefit of the doubt. I'm probably going to be going crazy sitting over here as Mr. Ring gets to make his rebuttal argument. But I can't say anything because that's the way the system is. I can't fight with him. I'm about to turn this over to you. I ask you to fight for it. You hear Mr. Ring make his points, you get to play defense attorney. What would Mr. Nichols have said if he got a chance to rebut the rebuttal? Really, it comes down to what did you see? What did you hear? Take all the evidence. You are the ones who decide the fact. What you decide is final when it comes to the facts. You can't change it. You won't change it. You come back not guilty, just means not proven. No one's going to be mad. Mr. Ring's not going to be mad. Judge Flores won't be mad. No one's going to arrest you on your way out of the courthouse. Okay? I believe that is the only way that is supported by evidence or lack of evidence based on reason, common sense. So the verdict I'm asking you to return is to check that box that says not. Thank you.
Thank you, counsel. Rebuttal from the people.
As the defense said, I do get the last chance to speak with you. And it's because I had that burden of proof. It's because I had that high burden. And it's a burden I gladly accept. And I'll talk to you about a little bit more, very briefly, just so we have some more context. The defendant got up on the stand and testified too. And she was all over the place. She could remember times when things happened. She could remember what order things happened in. She knew all the answers to the questions that defense asked her. But anytime I asked a question, it was usually, I don't know. I don't remember. But she knew everything the defense wanted to ask her. She knew all the answers to that. She got up. She got up here and told you how afraid she was. But I'd ask you as jurors, reasonably, is a person reasonably afraid when she said she was screaming at her from another room and shouting at her, but she went to confront her anyways? Is that reasonable to be afraid of somebody, to confront them when they're screaming and shouting at you? Are you really afraid of them? At another point, she said, I just wanted to leave and diffuse the situation, leave. But she didn't want Rachel to leave. She took the keys so she couldn't leave. How is that diffusing the situation or allowing somebody to leave? I submit to you, jurors, that it's not, that she wasn't afraid, that her actions during that time proved that she wasn't afraid. Defense also mentioned that it's not guilty if you all don't agree on the verdict. It's not a not guilty if you all don't agree on the verdict. Part 6 of that jury instruction for self-defense says that she must not have brought on the attack. She's claiming that she was aggressed at first. She must not have brought on that aggression. I would submit to you that going into a room where somebody's screaming and shouting is bringing on that aggression and bringing on that act. Defense said that the officers made a life-changing decision in the span of 10 minutes. That's not something you consider whether it was a life, ladies and gentlemen, that's not something you consider whether it was a life-changing decision or not. You're not allowed to consider possible penalty or any possible outcome of this. Rachel got up here and she told you about the text that she sent to her mom. And I would ask you, ladies and gentlemen, to look at that through the eyes of Rachel. Her parents are struggling in a divorce. She loves both of them. She doesn't want to choose a side. She got up here and told you she was afraid as well. She didn't know how her mom would react after everything. So I would just have you look at that through her eyes and think about what might have been going through her mind. And defense says the defendant needs somebody to fight for her. Boy sure looked like she fought very well for herself when she slapped her daughter. Ladies and gentlemen, I would ask that you find the defendant guilty of assault and battery. Thank you.
Thank you. All right, it's now time. I'm going to read the jury instructions. So members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law as it applies in this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors, who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe that what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way, decide the case. A person accused of crime is presumed to be innocent. This means that you must start with the presumption the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything, his or her innocence. If you find that the prosecutor has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I've told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They're only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by evidence or by your own common sense and general knowledge. The lawyer's questions of the witnesses and my question to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, ruling questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of a witness. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching, listening? Was anything else going on that might distract the witness? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness' age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influence that have affected how the witness testified? In general, does a witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does a witness's testimony seem when you think about the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about something but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor must prove in this case that the crime occurred on January 2nd, 2023 at the location of 2400 Northwest Avenue, City of Lansing, Ingham County. When you go to the jury room, you may take a written copy of the jury instructions with you along with your notes. You should first choose a foreperson. The fourth person should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phone or your other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agree on that verdict. In the jury room, you'll discuss the case among yourselves, but ultimately each of you will have to make up your own mind, and verdict must represent the individual considered judgment of each juror. It is your duty as juror to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you are wrong. Try your best to work out differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because others disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about jury instructions before you begin deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to the bailiff. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find the defendant actually made the statement as given to you. If you find the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence that normally or reasonably leads to the other facts. So taking that same example, if you see a person come in from outside wearing a raincoat with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence can be used to prove the elements of the crime. In other words, you should consider all the evidence that you believe. You've heard witnesses that before the trial, a witness may have made a statement that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial to help you decide how believable the witness's testimony was when testifying here in court. In the earlier statement, was the statement made under oath? Then you may all consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statement when determining the facts of this case. You should not decide the case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard testimony from a witness who's a police officer. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. To prove the charges, the prosecutor must prove each of the following elements beyond a reasonable doubt. The defendant is charged with assault or assault and battery. That Valerie Jean Ostrowski committed a battery on Rachel Ostrowski. A battery is a forceful, violent, or offensive touching of another person or something closely connected with the person of another. The touching must have been intended by the defendant. That is not accidental, and it must have been against Rachel Ostrowski's will. It does not matter whether the touching caused any injury. The defendant intended, part two of that is the defendant intended either to commit a battery upon Rachel Ostrowski or to make Rachel Ostrowski reasonably fear an immediate battery. Once again, the prosecutor must prove that beyond a reasonable doubt the crime occurred on January 2nd, 2023 at the location of 2400 Northwest Avenue, City of Lansing, Ingham County. The defendant does not have to prove that she acted in self-defense. Instead, the prosecutor must prove beyond a reasonable doubt that the defendant did not act in self-defense. The defendant claims that she acted in lawful self-defense. A person has a right to use force to defend herself under certain circumstances. If a person acts in lawful self-defense, her actions are justified, and she is not guilty of assault and/or assault and battery. You should consider all the evidence and use the following rules to decide whether the defendant acted in lawful self-defense. Remember to judge the defendant's conduct according to how the circumstances appeared to her at the time she acted. First, when she acted, the defendant must have honestly and reasonably believed that she had to use force to protect herself from the imminent unlawful use of force by another. If her belief was honest and reasonable, she could act at once to defend herself, even if it turns out later that she was wrong about how much danger she was in. Second, a person is only justified in using the degree of force that seems necessary at the time to protect herself from danger. The defendant must have used the kind of force that was appropriate to the attack made and the circumstances as she saw them. When you decide whether the force was used was what seemed necessary, you should consider whether the defendant knew about any other ways of protecting herself. But you must consider how the excitement of the moment affected the choice the defendant made. Third, the right to defend oneself only lasts as long as it seems necessary for the purpose of protection. Fourth, the person claiming self-defense does not have acted wrongfully and brought on the assault. There's been evidence that Rachel Ostrowski may have committed violent acts in the past and that the defendant knew about these acts. You may consider this evidence when you decide whether the defendant honestly and reasonably feared for her safety. When you go to the jury room, you'll be provided with a written copy of the final jury instructions. You should first choose a foreperson. This foreperson should see to it that your discussions are carried on in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual. Consider judgment of each juror. Possible penalty should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the court officer, Mr. Neves. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instruction. If you want to look at any or all of the reference documents or exhibits that have been admitted, just ask for them. If you want to see the video again, we may bring you back into the courtroom and show it to you on the big television, okay? When you go to the jury room, you'll be given a handwritten copy you'll be given a written copy of the instructions. You don't want a handwritten copy of the instructions. You've just heard. As you discuss the case, you should think about all my instructions as the law you are to follow. You may return a verdict of the alleged crime of assault and/or assault and battery or not guilty. I prepared a verdict form that my court officer has listing the possible verdicts. And at this time, I'm going to call the lucky or unlucky juror who has spent their entire afternoon with us and now will not take part in deliberation. And that is juror number 4, Lance Rose. Now, Mr. Rose, you may want to run out and get a lottery ticket or not, depending. But thank you for your service today, and thank you for your appearance today, Mr. Rose. Yeah. All right, I'm going to swear the court officer in that you will take care of the jury, and then we will go. This has been a problem in the past, surprisingly. You can deliberate as soon as you get there, all right? Don't wait for us to tell you to start. you can start. We'll put some stuff on the record if there anything has to be done on the record. But we've had jurors be out there 20 minutes and then say, can we start now? And that seems like 20 minutes. You should have probably been working on the verdict. So let's do that. I'm going to swear the court officer in. Officer Neves, raise your right hand. Do you solemnly swear that you will, to the utmost of your ability, keep the person sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them, that you will not communicate with them or any of them orally or otherwise, except by order of this court, or to ask them if they have agreed on their verdict until they shall be discharged, and they will not, before the render of verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon. So help you God. Thank you. All right. It is now time to deliberate. We have the jury instructions and exhibits. And then, so follow the court officer, he will take you to the deliberations, all right? And then you can go ahead and start. We may tell you to stop depending on the instructions of that, but go ahead and start your deliberations now, all right?
Oh, yeah, you just need to. I'll need a copy of the instructions.
I'll print off another copy. All right, we're back on the record. We'll make sure that door is shut. So we're back on the record. It is now 5:49 deliberation time. And any comment on the instructions or how the court provided the instructions from the people?
None for the people, thank you.
Mr. Moss or Mr. Nichols, anything concerning the instructions?
No, none.
All right, then we stand in recess for the jury verdict. I will go ahead and make a copy of the instructions so they have it, those part 3 instructions, and I'll give it to the court officer so that you can keep your instructions, all right?
Thank you, Judge.
All right, thank you. So. Yep.
I was gonna read it. I thought you were gonna
No,
say something.
no, I was gonna, well, I was gonna, that was great. Yeah, the jury was still wondering if they could ask. if they could
All
start-
rise for the jury.
All right, you can be seated. I've been told that the jury's reached a verdict. I have your verdict right here. I'll give it to my court officer who you picked a foreperson. That foreperson will announce it for the rest of the courtroom. It's juror number 1, I believe.
So we have reached a verdict of guilt.
Thank you. So jury, your time here is set. Does the defense want to voir dire the jury or go through the jury one at a time? All right. So I'll ask juror number 1, is that your verdict? Juror number 2, is that your verdict?
Yes.
Juror number 3, is that your verdict?
Yes.
Juror number 5, is that your verdict?
Yes.
Juror number 6, is that your verdict?
Yes.
Juror number 7, is that your verdict?
Yes.
Does that suffice? All right, thank you. All right, jury, your deliberation is done. There may be food there, there may not, I'm not certain. But thank you for your service today. This system does not work without jurors, okay? So thank you very much. And please, if you have any time, please enjoy the day. All right, thank you for your appearance today.
Thank you.
Judge, the verdict form, do you want him to leave it or?
Jason, you can leave the verdict form. My court officer will take care of that.
Awesome.
Thank you.
I turned that other fan on.
All right, so we're on the record in docket 23-00011. We read the verdict. The verdict was guilty at 6:17. And we will set this case for sentencing. Yeah, of course, you're not going to probation now, so you'll go in the next 48 hours, so it'd be by Thursday, I think, in order for any pre-sentence to be done. So sentencing date. Yeah, different set of facts. Let's do it. And we'll set it out. It's going to be 8 to 10 weeks, I think. But yeah, that's what we're looking at here, because I'm going to treat it as a brand new PSI. So it'll be set for July 6th.
I'm sorry, June 6th.
You thought I took it just as the date. Okay, so June 6th at 1:30 is the date of sentencing. So Mrs. Strowski, before Thursday at 4, go to probation on the fifth floor and make sure they understand they've got to do a report, answer any questions, and they'll prepare a report, and we'll see what options we have for June 6th. All the arraignment conditions are stay intact. Anything else for the record, Mr. Ring, on docket 23-00011?
Nothing on behalf of people. Thank you, Judge.
All right, Mr. Moss or Mr. Nichols, anything else on behalf of the defense?
Nothing, Your Honor.
All right. I would say all those no contact orders are still in place in regards to the victim in the case. So just stay in line with those no contact orders. All right, that's all for the record. 23-00011. And ma'am, you'll see you back on June 6th at 1:30. She left it. Right there.
Didn't even hear her.
Yeah.
Yeah, I just gotta remember where I put it.
There's the, she put it, Nathaniel might have taken it.
Jury.
The jury verdict, yeah, because she had it and she put it on Mr. Ring's side.
I just gotta make sure I put it in the file.
Okay. And I've got the file right here.
Okay. I gotta go find
Thank you,
that
Mr.
letter.
Moss.
Thank you, Your Honor.